We are requesting everyone to rise for the opening prayer to be led by the Honorable Congressman Rog Gutierrez, to be followed by the singing of the national anthem.
Let us put ourselves in the presence of the Lord. Heavenly Father, we come before you today with humility and reverence as we gather for this meeting of the Committee on Justice. We ask for your guidance as we take up preliminary matters, set the ground rules, and consider the processes that will shape our proceedings. Grant us wisdom and discernment as we begin the initial hearing of the determination of sufficient probable cause in the impeachment complaints before us. May we be guided not by personal interest or bias, but by a steadfast commitment to truth, fairness, and the rule of law. Help us listen with open minds, to speak with clarity and respect, and to act with integrity in every decision we make. Remind us that our duty is not only to the law, but to the people we serve and to the principles of justice that uphold our nation. May your spirit of justice and righteousness prevail in all our deliberations. This we pray in your holy name. Amen.
Amen.
Bayang magiliw, perlas ng silanganan, alab ng puso, sa dibdib mo'y buhay.
Lupang hinirang, duyan ka ng magiting. Sa manlulupi, di ka pasisingil.
Sa dagat ang tulong, sa simoy at sa langit mong lugaw. May dilag ang tula at awit sa paglayang minamahal.
Ang kislap ng watawat mo'y tagumpay na nagniningning.
Ang bituin at araw na kailan pa may di magdidilim.
Tumanang araw na walang ipagsira. Buhay ay langit sa pino. Sa pino ang higaya na may matali.
Mamatay ng dahil sa'yo.
The hearing of the Committee on Justice is hereby called to order.
Madam Chair,
The Honorable Zamora.
as this is a continuation of the hearing held on March 18, 2026, I move to dispense with the calling of the roll.
There is a motion to dispense with the calling of the roll. Do I hear a second?
Second, Madam Chair.
Is there any objection? Hearing none, the motion to dispense with the calling of the roll is hereby granted. Can I hear a motion on the reading of the minutes and its approval?
Madam Chair, I move to dispense with the reading of the minutes held last meeting, and I move for its approval.
There's a motion to dispense with the reading of the minutes of the last meeting and for its approval. Do I hear a second? Second. Is there any objection? Hearing none, the motion is approved. The reading of the minutes is dispensed with, and the same is approved. The Chair will address the Justice Committee. Magandang umaga po sa inyong lahat. Sa aking mga kapwa miyembro ng kapulungan, sa ating mga panauhin na naririto ngayon at sa sambayanang Pilipino. Before we begin, at bago natin ipagpatuloy itong proseso ng impeachment, tandaan natin na hindi lingid sa ating kaalaman na marami pa tayong ibang kinakaharap na problema. Let us accordingly acknowledge the pressing challenges our country faces. Oil prices are rising. The cost of basic goods is increasing. Ordinary Filipinos feel the weight of daily life more than ever. And yet, even as we undertake this solemn constitutional duty, the House of Representatives does not forget its other responsibilities. Kahit may impeachment, tuloy pa rin tayo sa iba nating obligasyon. We have, for example, acted to ease the burden of rising fuel cost, passing a bill authorizing the suspension or reduction of excise taxes. Nariyan na po ang panukalang batas, pinag-aralan, pinag-isipan, at inaasahang makatutulong sa ating mga kababayan. We also continue to work on measures that address inflation, food security, and social services. Also, just this March 2026, the House has acted on measures that directly affect the daily lives of Filipinos, passing a bill abolishing the travel tax, advancing legislation to institutionalize digital payments in government transactions, and pushing reforms to make public services more accessible and efficient. The House has also advanced key education reforms, including amendments to the Universal Access to Quality Tertiary Education Act and the Presidential Merit Scholarship Program. This strengthens support for students and investing as well in the country's future workforce. And after nationwide consultations across Luzon, Visayas, and Mindanao, the House has pushed forward the long-awaited anti-political dynasty bill with plenary deliberations recently completed. These actions remind us that governance is a constant balancing act, attending to urgent needs while fulfilling constitutional obligations. Kahit may impeachment, tuloy tayo sa iba nating tungkulin. Ang ating serbisyo publiko ay hindi napuputol, hindi tumitigil kahit sa gitna ng pinakamabigat na tungkulin. While we scrutinize those in power, we do not lose sight of the hardships faced by the powerless. Having said that, we proceed today fully aware of our dual duty to hold public officials accountable and to serve the people who entrusted us with this mandate. And so now, we begin. Dito nagsisimula ang opisyal na pagdinig ng kasong ito. Sa ating pagsisimula, tandaan natin na ang impeachment ay patungkol sa pananagutan sa bayan. Kaya't marapat lamang na balikan natin ang ating panunumpa. I do solemnly swear that I will faithfully and conscientiously fulfill my duties, preserve and defend the Constitution, execute its laws, do justice to every man, and consecrate myself to the service of the nation. Madaling bigkasin, pero mahirap panindigan. Hindi ito simpleng ritual. Ito ay isang pangako, isang panata ng pananagutan, hindi lamang sa batas, kung hindi sa bayan. Let me lay out the agenda for today. First, we establish the ground rules or the guidelines, not as obstacles, but as safeguards. Their purpose is simple: to maintain order, to allow clarity, so that truth may emerge unimpeded. Ang patakaran ay hindi hadlang sa katotohanan. Ito ang daan upang ito'y malinaw na lumitaw. Second, we move to the initial hearing. Opisyal po nating buksan ang pagdinig sa impeachment na ito. Third, and as part of this initial hearing, we act on pending motions, request for subpoenas, and set the schedule for the next hearings. At the core of these proceedings is probable cause. That is the objective of these hearings. We shall determine whether there is probable cause for impeachment. Ngunit, paano ba natin masasabi na merong probable cause? Let us be clear. This is not the probable cause of criminal procedure. Impeachment is not a criminal trial. It is a constitutional and policy exercise entrusted not to the courts, but to the House of Representatives. As we have seen in previous proceedings against Ombudsman Mercedes Gutierrez, the classical legal definition of probable cause was not applied. And for good reason. Impeachment calls for judgment, not mere calculation. It asks not only what can be proven, but what can be justified before the people. As the late Father Joaquin Bernas said, impeachment is about what is best for the country. Hindi lang ito tanong ng kung ano ang nasa batas. Ito rin ay tanong ng kapakanan ng bayan. Consider the ground of betrayal of public trust. What does it mean? Can it be reduced to a single act? A measurable threshold? Or is it something more? Something felt as much as it is proven? Paano mo susukatin ang pagtataksil sa tiwala? Sa bilang ba ng ebidensya o sa bigat ng paglabag? We are confronted with serious allegations, threats against the President, accumulation of ill-gotten wealth, SALN violations, misuse of confidential funds, disregard of safeguards for transparency, and defiance of constitutional process. These are not trivial matters. They go to the very heart of public trust. May mga kasalanang hindi kailangang ipaliwanag, ramdam agad ng taong bayan. The truth is, betrayal of public trust resist rigid definition. And if the standard is not mechanical, neither can the threshold to examine it be mechanical. Kung ang batayan ay may bahid ng moralidad, ang paghusga ay hindi maiiwasan dumaan sa konsensya. Conscience becomes our guide, not as a substitute for evidence, but as its interpreter. Evidence tells us what happened. Conscience tells us what it means. Ang batas ang nagbibigay ng balangkas. Ang konsensya ang magbibigay ng kahulugan. Therefore, to determine probable cause, is to listen, to weigh, and to decide, not by rigid formulas alone, but by what is just and right for the Filipino people. Ngunit malinaw sa atin, ang araw na ito ay simula pa lamang. Sa mga darating na linggo, sa mga susunod na pagdinig, hihimayin natin ang mga aligasyon isa-isa. Susuriin ang bawat ebidensya. Magtatawag tayo ng mga testigo. Pakikinggan ang bawat argumento at titimbangin ang depensa. Today is just the beginning of a process that demands patience, discipline, and vigilance. At sa prosesong ito, sisikapin nating maging tapat, hindi lamang sa batas, kundi sa sambayanang Pilipino. And in the search for probable cause, let us remember that what we are conducting here is merely investigative in nature, where the question is not guilt, but whether there is sufficient basis to proceed to trial in the Senate. At this stage, in this committee, there is no deprivation. No one is being removed from office here. No one is being disqualified. No final judgment is being rendered. Those consequences, if they are to come at all, arise only in the Senate, where the trial is held, where the evidence is fully ventilated, and where the full measure of due process applies. But this is not to say that due process is absent here. Far from it. We have to remember that whatever we do here in the committee must always be in accordance with the Constitution, particularly the demands of due process. The Vice President has been invited to participate. She is reportedly prepared for a full-scale legal battle. A bloodbath, as it has been described, assembling a very large team of lawyers. She is apparently ready to face the accusations and defend herself at length. And yet it appears she will not even participate. We recall the words of Justice Antonio Tiham in the previous impeachment against Chief Justice Maria Lourdes Sireno. Failure to participate in the hearings before the Committee on Justice is tantamount to a culpable violation of the Constitution. Ayon sa pananaw na iyon, ang hindi pagharap sa proseso ay maaaring ituring na patuloy na paglabag sa saligang batas. Ang tanong ngayon, maaari rin ba nating sabihin ito sa Vice Presidente? Let us remember, the Vice President took the same oath. I do solemnly swear that I will faithfully and conscientiously fulfill my duties, preserve and defend the Constitution, execute its laws, do justice to every man, and consecrate myself to the service of the nation. Lahat ho ng kawani ng gobyerno, lahat ng opisyal ng pamahalaan, iisa ang panunumpa, iisa ang pamantayan, iisa ang pananagutan. Ang panunumpang ito ay hindi lamang pangako ng panunungkulan. Ito ay panata ng pagharap sa pananagutan at paggalang sa saligang batas. Dito sa komite, susundan natin ang saligang batas. Hindi natin tatalikuran ang ating tungkulin. Iyan ang inaasahan ng taong bayan. Hindi pag-iwas, kundi pagharap. Hindi katahimikan, kundi pananagutan. Sapagkat ang panunumpa ay hindi lamang binibigkas sa simula. Ito ay pinatutunayan sa bawat pagkakataon na tayo ay sinusubok. So regardless of the participation of the Vice President, and even in her absence, this committee will proceed. We will do our duty with resolve, without hesitation, and without delay. The Constitution entrusts the House with the exclusive power to initiate impeachment cases, and this committee stands at the forefront of that responsibility. Tayo lamang, ang Committee on Justice lamang, ang tahasang binigyan ng ganitong tungkulin sa saligang batas. In the end, this is not merely a procedural exercise. This is a test of judgment, of conscience, and of courage. Let us proceed with diligence, with fairness, with honesty, knowing that our actions today will echo far beyond this chamber. And so we return to where we began. Sa huli, babalik tayo sa ating panunumpa. I do solemnly swear that I will faithfully and conscientiously fulfill my duties, preserve and defend the Constitution, execute its laws, do justice to every man, and consecrate myself to the service of the nation. Madaling bigkasin, pero mahirap panindigan. Ang tanong, para sa lahat ng kawani ng gobyerno, para sa lahat ng opisyal ng pamahalaan, para sa vice-presidente, tinutupad ba natin ito? Pinaninindigan ba natin ito? Iyan ang tanong na sisimulan nating sagutin dito sa impeachment na ito. Maraming salamat po. We now call the case. Committee Secretary.
Thank you, Your Honor. Initial hearing on the impeachment complaints against Vice President Sara Z. Duterte, filed by Reverend Father Joel Saballa et al. And endorsed by Representative Laila M. De Lima, and filed by Attorney Nathaniel G. Cabrera, and endorsed by Representatives Bienvenido M. Abate Jr. and Francisco Paulo P. Ortega V.
Madam Chair,
The Honorable Jokno.
may I be allowed to make a brief manifestation
Which manifestation?
in relation to the opening statement?
The opening statement.
made by
You may
the
proceed,
Chair.
the Honorable Jokno.
Thank you, Madam Chair, distinguished colleagues, mga kababayan natin na nanonood, at magandang umaga po sa atin lahat. Marami po nagtatanong, ano ba talaga itong impeachment at ano ba ang proseso sa impeachment? Klarong-klaro po sa ating konstitusyon, Article 11, Section 3, the House of Representatives has the exclusive power to initiate all cases of impeachment, while the Senate has the sole power to try and decide all cases of impeachment. Sa madaling salita, ang Kongreso ang nagsasampa o naghahain ng impeachment case, habang ang Senado naman ang nagsisilbing hukom o tagahatol. Kaya tayo nandito sa hearing na ito ay para malaman, dapat nga bang isampa ang impeachment case laban sa Vice Presidente? Nung nakaraan, nakita po natin na sufficient in form and substance ang dalawang impeachment complaint. Ibig sabihin nito, sapat o tama ang forma ng mga reklamo at may sapat na nilalaman para umusad tayo sa pagdinig na ito. Nakita din ng committee na ang impeachment complaint ay sufficient in grounds o may sapat na batayan. Sa puntong ito, mismo ang konstitusyon ang nag-uutos sa Committee on Justice na magsagawa ng hearing. Ano naman ang ihihiring natin? Siyempre, walang iba kundi ang ebidensya at testigo. Our duty is clear, Madam Chair. This committee must secure and verify every piece of evidence, and we must protect every witness so they may give their testimony under oath. Ito ay naaayon mismo sa Section 7 at 8 ng Rules of Impeachment. Itong dahilan kung bakit po tayo naghain ng motion para makuha ang kopya ng salin ng Vice Presidente at para bigyan ng proteksyon ang testigo na si Mr. Ramil Madriaga. Ang impeachment case na ito ay dadaan sa butas ng karayom. This is the only way for the truth to come out. Pagkatapos ng committee, boboto po ang buong Kamara at magpapasya kung dapat ilitis ang kaso sa Senado. At sa bawat hakbang, nakatutok ang buong bansa para bantayan ang proseso. Maraming salamat po. Thank you, Madam Chair.
The manifestation of the Honorable Jokno is noted by the committee.
Madam Chair.
The
also-
Honorable Dilima.
Also a brief manifestation and a question to the Honorable Chair and the Committee
With the indulgence
Secretariat.
of the Honorable Dilima, we would like to tackle first our ground rules before we proceed to your subsequent manifestations and questions to the committee.
Thank you, Madam Chair. Thank you.
Madam Chair.
Regarding the ground rules, we would like to acknowledge Vice Chair Zamora.
Thank you, Madam Chair. Bago po tayo magsimula sa deliberasyon ukol sa pagtukoy ng probable cause sa impeachment proceedings na ito, kinakailangan magtakda ng ating chairperson ng ilang panuntunan upang matiyak ang maayos, patas at episyenteng pagtatalakay. Ang komite ay may 38 na regular members. Ang quorum ay 1/5 ng kabuuan. Ang ex-officio members ay may boses at may boto. Ang mga nais magsalita ay kailangan makipag-ugnayan sa committee secretary upang maitala ang kanilang pangalan. Magkakaroon tayo ng alternating recognition ng minority at majority na may 5 minuto bawat isa. Maaari tayong magbigay ng second round kung may oras pa po. Hinihiling ng chairperson na hintayin muna ang kanyang pagkilala bago magsalita upang mapanatili ang kaayusan. Sa mismong pagdinig, ang mga resource persons ay susuriin ng mga miyembro ng komite alinsunod sa Section 7 of the Rules of Procedure in Impeachment Proceedings. Ang mga resource persons ay hindi papayagang magsalita o gumawa ng mga interjection malibang kung at hanggang sa sila ay kilalanin ng ating chairperson. Tanging ang mga miyembro ng komite lamang ang may karapatang suriin o i-cross-examine ang mga resource persons. Ang mga partido ay maaaring humingi ng pahintulot mula sa chairperson na magsumite ng mga tanong na itatanong ng ating chairperson kung sa kanyang opinyon ay kinakailangan ang mga ito para maging malinaw ang talakayan. Ang pakikilahok ng mga abogado ng mga partido o resource persons ay limitado sa pagpapayo sa kanilang mga kliyente tungkol sa kanilang mga karapatan sa ilalim ng konstitusyon. Dapat silang sumunod sa wastong kagandahang asal at hindi sila papayagang magsalita o gumawa ng mga interjection malibang kung at hanggang sa sila ay kausapin o kilalanin ng chairperson. Mga kasama, impeachment is an extraordinary constitutional process. It demands sobriety, discipline, and unwavering respect for the rule of law. Hindi personalidad ang ating hinaharap ngayon, kundi ang ating constitutional duties. Thank you very much, Madam Chair.
Can we hear the necessary motion for the adoption of ground rules?
Madam Chair, I move to adopt the ground rules as stated earlier.
There is a motion to adopt the ground rules read by the Honorable Zamora. Do I hear a second?
Madam Chair,
Is there any objection?
discussion. Madam
The Honorable Rodriguez.
Madam Chair, the right to counsel is assured by the Constitution. So therefore, the respondent here has always have the right to counsel. In fact, in many cases, our rules of court is supplementary to the rules of impeachment in the House. And so therefore, this representation believes that first, they are entitled, counsels for both sides are entitled to send questions, and I agree with that, Madam Chair. But what I would like to emphasize is that the Vice President can always designate their counsel to appear in all the proceedings, so that we should be able to state there that the right to counsel, the right to be heard by herself or counsel is assured by the Constitution. But we know the response of the proponent of the motion as to that particular observation.
If I may confirm, the Honorable Rodriguez, you would like the committee to acknowledge the right of the counsel even in the absence of the respondent.
That's correct. Based on jurisprudence, Madam Chair, that although this is not a criminal proceeding, it is akin to a criminal case because we are trying to remove and there is also perpetual disqualification. And so, in other words, the Vice President can send her counsels here to appear for her. In fact, the right to self-incrimination is there. And a person who is now being investigated has the right to already not take the stand or at the time she wants to appear to be able to invoke it when she is asked an incriminatory question. So that is the position of this counsel. Thank you, Madam Chair.
Of course, based on the ground rules that was read by the Honorable Zamora, the right to counsel is described as assistance to clients or to the parties. Now it is being proposed by the Honorable Rodriguez that the same be acknowledged even in the absence of the respondent or the parties. May I hear the comment of the members of the Justice Committee?
Madam Chair.
The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. I agree if that is on the presentation of the complaint's evidence. But at the time the respondent will be presenting her evidence, she must be present because who will answer clarificatory questions in cross-examinations of what will be presented? She is the only one. The counsel are not witnesses in this particular case. So I hope my colleague will agree that at the time the respondent is given the opportunity to present her evidence, she must be present. Thank you, Madam Chair.
Would you like to clarify the extent of the participation that you are proposing?
Yes, Madam Chair. What I am proposing is, at the time that we have concluded the presentation of the evidence of the complainants, and it will be the turn of the respondents, then the respondents or her witnesses must be present because they are the only ones who can answer clarificatory questions or cross-examination questions of any of the members of this committee. The lawyers of the respondents are not witnesses to the said defense of the respondent. So it is a must, Madam Chair, that she must be present at the unless she will waive the presentation of her evidence when it is her time to present her evidence pursuant to our rules of impeachment, Madam Chair.
For purposes of accuracy, Honorable Vice Chair Dumogan, you are proposing that the respondent's counsel, even in her absence, be allowed to present the evidence. But for purposes of clarificatory hearing, it should be the Vice President herself who should be present and answer the questions before the Justice Committee.
That's exactly correct, Madam Chair.
Thank you. Any other member who
Madam
wish to
Chair.
manifest? The Honorable Rodriguez.
Madam Chair, the right against self-incrimination is very clear. Under our rules, the criminal procedure rules, which are suppletory, because our rules are very, very, very pithy in terms of the procedure. 2 points, Madam Chair. The respondent has the right not to appear, and therefore she does not need to be present, because that is the right of a respondent, akin to a accused in a criminal case, as decided in the cases, Madam Chair. That's number one. Number two, the counsels here are not only to advise on the legal rights, they have the right to cross-examine, because the Vice President will not be present. If she's present, she cannot cross-examine witnesses, because she has lawyers. So therefore, 2 points. The rule that requires that lawyers can only, the participation is only to advise the legal rights of the witness is on the rules on the investigation in aid of legislation. That is expressly found in the rules in aid of legislation, the hearings. But it is not found in our rules. I've been reading our rules of procedure. There's nothing here that limits it to only advising. Therefore, in an adversary proceeding like this, we have to therefore hear the counsels if they wish to be present, but if not, then that is also the lookout of the respondent. But I believe that we should be clear in our rules that the presence of counsel of the respondent has the right to cross-examine directly the witnesses for the complainants. And secondly, there is no need for the Vice President to appear in hearing, because that is her right not to be able to appear, and we can make conclusions out of her non-appearance. No need for her to appear. Thank you, Madam Chair.
Madam Chair.
Madam,
The Honorable Chua, are you raising your hand?
No. Madam Chair.
The Honorable Vice Chair Dumogan.
The first part of the point had already been settled. Under our own rules, which is the subject of the motion, the counsel of the respondents are allowed to cross-examine by writing their questions, submitting it to the chair. What I am pointing out, Madam Chair, is at the time the respondent is given the opportunity to present her evidence. Well, counsel may present her evidence, but she must be present, or the witnesses that she is presenting must be present, so that the members of the committee will have the chance to examine or ask clarificatory questions from them. The counsels are not witnesses to the defense of the respondents, Madam Chair. Thank you, Madam Chair.
For the guidance of the justice members, part of the proposed rule is giving opportunity to the complainant and the respondent and their counsels to submit questions to the chairperson so that they may be raised in the deliberation if no justice members are raising similar questions. Let us all be guided as well that the hearing proper in the Justice Committee is akin to a preliminary investigation. So, let us be guided by the fact that as well, that we're trying to establish here is merely probable cause, which means a justification to be able to proceed to trial, which will definitely happen not here, but in the Senate.
Madam
The
Chair.
Honorable Chua.
Thank you, Madam Chair. Madam Chair, let me read what is provided under our rules, the rules of procedure in impeachment proceeding. Under Section 7, it provides that if the committee finds that there is sufficient ground for impeachment exists, the committee shall conduct a hearing, which we are now doing. The committee, through the chairperson, may limit the period of examination and cross-examination by members of the committee. Therefore, Madam Chair, it is very clear under our rules that it is only the members of the committee who can participate with respect to the examination and cross-examination of the members. Why? Because, like what you said a while ago, this is akin to the preliminary investigation wherein it is the investigating officer or the investigating city prosecutor who is asking clarificatory questions. We are not yet in the trial where the lawyers or counsel of the defendant can cross-examine the witnesses. Now, this can also be, we can also be guided by our rules of procedure governing inquiries in aid of legislation, which the Honorable Rufus Rodriguez mentioned a while ago, that under Section 13, appearance of counsel, here, the participation of counsel for witness during the hearing and while the witness is testifying shall be limited to advising on the legal rights of said witness. Why? Because this is a committee function. So ganun din po dito. Ito pong ginagawa natin is also a committee function. The cross-examination, ang purpose po ng cross-examination dito is just to ask or just to clarify questions. Hindi pa po ito yung talagang trial proper wherein we can cross-examine thoroughly the witnesses. Thank you, Madam Chair.
Madam Chair.
Thank you. The Honorable De Lima.
Thank you, Madam Chair. I concur with the views expressed by the Honorable Joel Chua. As expressed very clearly by the Honorable Chair earlier, the proceedings today, or the proceedings from now on, henceforth, would be the determination of probable cause. And therefore, this proceedings is indeed akin to a preliminary investigation. There are no formal direct examination or cross-examination in the proceedings before the prosecutor's office. Yes, we can recognize the respondents and the complainants' right to counsel, but their role ought to be limited because this is only preliminary investigation. Role like identifying affidavits can assist their clients, can assist the complainants, or can assist the respondent. But if they have questions, as expressed and as already laid down in the ground rules read by the Honorable Representative Zamora, they can course it through the chair. In that case, they are afforded the right to confront, the right to ask clarificatory questions. This is not a full-blown trial yet that happens in the Senate. Just to repeat, this is akin to preliminary investigation, determination of probable cause. The proceedings or the hearings before the prosecutor's office, and this is the prosecutors, the Committee on Justice, is actually also limited, and no full-blown examination, whether it's direct examination or cross-examination, being conducted or held at that point. So I think it's very clear, as expressed by the Honorable Chair, and also indicated in the ground rules. We are not denying the parties their right to counsel. They have the right to counsel. They can assist for purposes especially also of asking clarificatory questions, but we have our own rules here, coursed through the Honorable Chair. Thank you.
Madam Chair.
The Honorable Ridon and then the Honorable Rodriguez.
Well, maganda po yung talakayan kanina patungkol doon sa konsepto no, ng karapatan sa pagkakaroon po ng abogado. But I think just for the record, meron pong sulat yung mga abogado ni Vice President Sara Duterte na wala naman po ata talaga din silang interest at this point na dumalo either ang pangalawang Pangulo o yung mga abogado po mismo. And I will read it for the record.
Madam
This,
Chair, we are still on our ground rules discussion. So that can probably wait and we will be able to discuss that.
No, just
because
to-
we are now on approving the ground rules. We are not yet determining what the Council or the Vice President is proposing or manifesting to us.
For
So
the guidance of the Justice members, there is a pending motion for the approval of the ground rules read by the Honorable Zamora. Perhaps we will be proceeding to the letter sent by the lawyers of the respondent after we address the motion for the approval of the ground rules.
Yes, Madam Chair, but just to make the point that even if we talk about a conceptual matter relating to the right to counsel, if the counsels themselves are actually questioning these proceedings and the Vice President herself is questioning this proceeding, I think that needs to be placed on record, Madam Chair. So I will read it. For two Narvasas and Salazar.
Madam Chair.
The Honorable
Committee.
Ridon
That will
is
be out of order.
requested to defer the discussion on the letter of Fortuna Narvasa until we address the pending motion before the committee.
Be submitted
So
to
if
the
we can go back to the motion, the
Madam
same
Chair.
has been seconded already.
other discussion because there were interjections.
That is with regards to
the
the ground rules.
Yes, Madam
The
Chair.
Honorable Rodriguez.
Madam Chair, there is here a statement that in our rules, only members can ask questions. And I would refer now to Section 7, committee finds, and then the committee shall conduct a hearing and examination and cross-examination by members of the committee. Very clear. However, Section 7 shall obey the Constitution of the Republic of the Philippines. The Bill of Rights, Madam Chair, Article 3, provides that the right to be heard by himself or herself or to counsel is inviolable. It is in paragraph, in section, in the rules, in the Bill of Rights, is in the section on Section 2, and then also on custodial Section 2 and Section 4. So, Mr. Chairman, I am saying that we just have to give the right, otherwise there will be no due process. If only the members
Chair.
can ask, we should allow,
Madam
can I finish
Chair,
first,
they
Madam
have
Chair?
the right.
I have allowed my good chair to finish, so let me finish my manifestation. So therefore, Madam Chair, it is very clear that councils should be allowed to cross-examine. Now, the issue here is that the rules provide that they submit the questions to the chairman. Will the chairman have the discretion to read or not? Or everything that will be given to the chairman will be read?
To answer the question of the Honorable Rodriguez, so long as the question is germane to the discussion pending before the committee, the chair will read the questions which are being submitted or which will be submitted by the councils of the parties. That includes the council of the respondent.
Thank you, Madam Chair. But
Madam
just to
Chair.
be able to state that this representation believes to be able to afford really procedural due process as pronounced in the leading case of Angtibay versus CIR. The 7 cardinal rights of a person who is accused, in this case, akin. We are really, this is even more than a criminal case because we are trying to remove the official who had the highest votes in the history of this country as Vice President. So what I'm saying, Madam Chair, we should allow the councils to appear if they so wish and be able to cross-examine the witnesses of the complainants. That is the way to be able to afford the opportunity of procedural due process as is written in Article 1 of Article 3 of Section 1 of the Constitution.
Madam
Let
Chair.
us be guided by the fact that this is not yet the trial.
Madam Chair, may
So
I be
what
allowed?
will happen before the Justice Committee is indeed merely a clarificatory hearing. Trial is different because, as has been repeatedly stated, only the Senate can conduct the trial.
Madam
What
Chair.
will happen before us is merely clarificatory hearing, and those questions are to be raised by the justice members. Of course, the lawyers of the respondent are free to attend the hearings. But with respect to their participation, I think that has been addressed in the proposed ground rules, that their questions may be submitted to the justice chairperson, who will be reading those questions to be answered by the resource persons.
Madam
Let
Chair.
us draw the line between the clarificatory hearing, between the Justice Committee and the trial, which will happen in the event that there is probable cause in the Senate only.
Madam Chair.
The Honorable Chua.
Thank you, Madam Chair. To answer the manifestation of my professor, the Honorable Rufus Rodriguez, there is no violation of due process, Madam Chair. Why? Because the respondent was given the opportunity to answer. That was the time when she is allowed to give all her answer. Now, sinasabi po natin that this is akin to preliminary investigation. Sa preliminary investigation po ba, did we allow the complainant and the counsel to cross-examine? No. It was only the investigating prosecutor who is allowed to propound question to clarify. Hindi pa po ito yung full-blown trial. And us, as member of the Justice Committee, that is our job, to ask clarificatory questions. Yun po yung intention nito. To do otherwise, kung iba po yung nasa isip nito, dapat clearly and expressly nilagay po dito sa ating rules na yung examination and cross-examination can be conducted by members of the committee and or counsel and the complainant. Kaso hindi naman po ganun eh. Sa buong Pilipinas, wala po kayo, never po nangyari sa preliminary investigation, nagkaroon ng cross-examination or nagkaroon ng opportunity na mag-cross-examine ang counsel at ang complainant. Thank you, Madam Chair.
Madam Chair.
Madam Chair.
Madam Chair.
The Honorable Zamora and then the Honorable Vice Chair Dumogan.
Madam Chair, I reiterate my motion to approve, to adopt the ground rules as I earlier stated.
In the interest of due process, let's hear as the last manifestation on the issue of representation by counsel, the Honorable Zamora, the Honorable Dumogan, and then we rule on the motion to approve the ground rules. Honorable Dumogan.
Thank you, Madam Chair. As I said, we fully is in the motion that respondent is entitled to counsel. In her counsel are entitled to ask clarificatory question, but it must be coursed through the chair, who will read the questions. That is the same in a preliminary investigation in a criminal case. But on the other hand, after the complainants had presented their evidence, it will now be the turn of the respondent. When the turn of the respondent will come, counsel can possibly present also the evidence of the respondent. But, as I said, the respondent must be present because who will now answer clarificatory questions from the investigators? The members of the committee are considered as the fiscal conducting an investigation. So, who will now answer the clarificatory questions of this committee if the respondent will not be here? So, anyway, it will be her right if she does not appear. But to me, it will be a waiver of her right also to answer clarificatory questions of any members of this committee. respectfully submit.
Thank you. At this juncture, we shall now resolve
Madam Chair,
the motion. I think
another-
we've heard already
No,
all
another
your meaningful and significant manifestations on the right to be represented by counsel. So with the indulgence of the
Madam
Honorable
Chair,
Zamora.
there is a next ground rule which I would like to again manifest. We're finished with the representation and
Okay.
presence.
You may proceed on the
I'd
next
like-
ground rule.
I would like to ask our Vice Chair, after the issue of the questions to be sent, what is the next ground rule? Because I have also a manifestation on that.
The last one is ang pakikilahok ng mga abogado ng mga partido o resource person ay limitado sa pagpapayo sa kanilang mga kliyente tungkol sa kanilang mga karapatan batay sa konstitusyon.
Madam Chair, I would object to that because precisely the rules of investigations in aid of legislation, that is precisely included. But it is not included in the rules of impeachment. Plus, secondly, lawyers will be allowed, in fact, that will contradict the previous ground rule because the lawyers of respondents are allowed to send questions to the chairman. So if you are preventing them only to advise counsel on their legal rights, that is what is stated in the rules in aid of legislation, then that should fall. Because we have allowed already in the first ground rule that there will be questions on cross-examination to be submitted to the chair. So the counsel is not limited to giving advice on the legal rights, the right to counsel, the right to right against self-incrimination, but really to participate through the chair. So I therefore move that we remove the
Madam
last
Chair,
one.
if I may comment,
The Honorable
please.
Zamora.
Madam Chair, number 8 and number 9 of the ground rules are not inconsistent with each other. Number 8 refers to the right of the parties to submit questions to the chairperson in case, and the chairperson has the right or has the discretion to propound these questions to the
resource
parties.
person.
For number 9, Madam Chair, the statement that the parties and their counsels, the counsels are limited to advising their clients about their rights under the Constitution is actually a very general statement that, yes, we should follow what is stated in the Constitution. So, in fact, it says here, dapat silang sumunod sa wastong kagandahang asal at hindi sila papayagang magsalita o gumawa ng mga interjection maliban kung at hanggang sa sila ay kausapin o kilalanin ng chairperson. So this is in fact a very general statement, Madam Chair. And again, as we are in a preliminary investigation stage, we are not violating the right of the respondent to counsel. In fact, I would like to make it a point that the respondent and his counsel and her counsels are not present. Thank you, Madam Chair.
Thank you. Any other manifestation? We are
Madam
on
Chair.
number 9
Madam Chair.
ground rules of impeachment, of the
Madam
hearing
Chair.
proper. The Honorable Tino.
Madam Chair, this is just a request for copies, even electronic
Yes.
copies of the ground
Yes,
rules.
may we
under
direct the committee
consideration.
secretary to provide the members with a copy of the ground rules?
Madam Chair, manifestation.
The Honorable D.S. Puno.
I refer back to the comment of the chairperson earlier that the questions being raised by the lawyers be coursed through her for determination on whether or not they are germane to the discussion. This leads us, Madam Chair, to the question of what is this committee tasked with deciding? Are we going to decide veracity or non-veracity of evidence? Or are we merely made to decide whether the evidence presented by the complainants are relevant to the complaint that they have submitted? When we forward whatever decision we make to the Senate, do we say that contrary to a preliminary investigation, that there is probable cause? I do not think that that is the obligation of this committee. I believe, Madam Chair, that the obligation of this committee is to verify that the witnesses presented will present testimony that are consistent with the complaints that we have already ruled as of substance and form. So maybe the right to counsel is not properly addressed here because we're not after truth or falsehood of the evidence that's coming in, merely relevance to the complaint that have been submitted by the complainant. When we elevate it to the Senate, we are not saying that anything is true or not true. We're not saying that anybody is guilty or not guilty. We're merely saying that the complaints have been found to be in form and substance. The witnesses presented have been consistent with the complaints that have been submitted. And that is going to be the substance of the decision that this committee will make, Madam Chair.
Thank you. And in addition to that, let us be reminded that part of the ground rules is allowing the lawyers of the parties, that includes the lawyers of the Vice President, to submit their questions to the chairperson so that the chairperson can raise them to the resource persons or even to the parties in the case or the witnesses, so long as the same is germane to the impeachment proceedings. So with that, may we
Madam
proceed
Chair.
to
Madam
rule
Chair.
on the motion?
Madam
The
Chair.
Honorable Ko and then the Honorable Jokno.
Thank you, Madam Chair. Madam Chair, I would concur with Representative Joel Chua and the current stipulation of the ground rules and find no contradictions, whether it be in the Constitution, in the House rules as we speak, and in the principles of due process that we are providing the respondent as of now. Also to clarify, the process that is on the floor right now is so that this committee, at the end of the succeeding hearings that we will be holding, makita natin kung may probable cause or hindi. Kung mag-proceed, na dapat mag-proceed to a full-blown trial o hindi sa Senado, yung complaints at bar. No? And to that end, isang step beyond sufficiency of substance and yung relevance na laman ng mga complaints, yung dapat i-determine ng mga members of this committee and the committee at the end of the day. That's why, for me, kailangan din po yung hindi lang presence ng respondent, but rather yung meaningful advice that the lawyers can provide, which is sufficiently detailed naman na po doon sa ground rules na pinopropose. So, Madam Chair, if necessary, I would like to second the motion as on the approval of the ground rules.
After the manifestation of the Honorable Jokno.
Thank you, Madam Chair. To ensure consistency and as well avoid the possibility of any litigation that may question the rules of the committee, perhaps the committee could entertain a possible amendment to the proposed House rules. The last provision, to make it clear, could state that the participation of counsel shall be limited, number one, to assisting their client, number two, to submitting questions to the chair, and number three, to filing whatever appropriate manifestations they choose to, and if required by the committee, a memorandum as stated in the rules on impeachment. That way, there can be no issue as to, no one can argue that the right to counsel is being denied by the committee. I would make so move, Madam Chair.
Second.
Second.
That is a motion for, if I may be clarified, Honorable Jokno? Because there is a pending motion as well for the approval of this ground rules. So may we hear first, before the second motion, that is for the amendment, if the proponent of that ground rules is accepting your proposed amendment.
Madam Chair, can I just insert this
Kindly wait to be recognized, Vice Chair Dumogan.
Madam Chair,
please.
I accept the restating of the ground rules as amended by the Honorable Jokno, and I would like to point out that these are just ground rules and not rules of the House of Representatives. These are just the ground rules of the Committee on Justice.
With the acceptance by the proponent of the amendment by the Honorable Jokno, may I hear the necessary motion to approve the amended ground rules?
So
Vice
moved,
Chair
Ms.
Zamora.
So moved, Madam Chair.
Second, Madam Chair.
There is a motion to approve the amended ground rules by the Honorable Dumogan. It has been seconded. Is there any objection? Hearing none, the amended ground rules is hereby approved. Now we proceed to the next matter. Earlier, the Honorable Redon is manifesting a letter received from Fortune Narvasa Law Office. Now we recognize the Honorable Redon for that matter.
Madam Chair, the counsels of Vice President Sara Duterte, Fortune Narvasa Salazar, and Attorney Michael Wesley Poa submitted a letter explaining the Vice President's absence today and their absence as well as counsels for the Vice President. And I will read the main basis for their objection to attending today. Under these circumstances and considering the public statements made by the chairperson, it appears that the committee intends to conduct a trial. I think, Madam Chair, the House Committee on Justice should confront this accusation squarely today. This particular position of the counsels and of the Vice President herself is basically a legal word salad. Ibig sabihin po, wala po itong batayan sa katotohanan. Ito po ay legal na pagpapalusot para lusutan na naman pong muli ang pagpapanagot sa mga impeachable offenses laban sa atin pong pangalawang Pangulo. Yung pong paggamit ng mini trial ng ilan po sa mga kinatawan ng komite pong ito ay para lamang po sa pagpapaliwanag sa atin pong mga kababayan nung pong pagtakbo ng proseso po na impeachment. Particular, ito pong hearing proper at more particularly to make a distinction from the actual trial which will happen at the Senate. No? So, tingin ko yun lang po yung malinaw po na distinction dito po sa bagay po na ito. And Madam Chair, there is nothing in the rules and the proceedings that we have today which can in fact be considered as unconstitutional. I will read for the record the rules yet again and the constitutional provision. The constitutional provision in Article 9, Accountability of Public Officers, Section 3, 2. A verified complaint for impeachment may be filed by any member of the House of Representatives or by a citizen upon a resolution of endorsement by any member thereof, which shall be included in the order of business within 10 session days and referred to the proper committee within 3 session days thereafter. The committee, after hearing, this hearing, Madam Chair, and by a majority vote of all its members, shall submit its report to the House within 60 session days from such referral, together with the corresponding resolution. That is the constitutional provision, Madam Chair. The rules of impeachment of the 20th Congress, Section 7, submission of evidence and memoranda. If the committee finds that sufficient grounds for impeachment exist, the committee shall conduct a hearing. This hearing, Madam Chair. The committee, through the chairperson, may limit the period of examination and cross-examination by members of the committee. The committee shall have the power to issue compulsory processes for the attendance of witnesses and the production of documents and other related evidence. These are particular provisions which guide the hearing proper today. And therefore, Madam Chair, hearing is mentioned in both the Constitution and the rules. This is the hearing proper that is mentioned in the Constitution and the rules. And part of hearing, any hearing, is the receipt of evidence. Ang sinasabi po ng mga abogado ng pangalawang Pangulo, wala daw pong karapatan ang komite pong ito sa yugtong ito na tumanggap po ng mga ebidensya. Pero alam po natin na sa mga pagdinig, bahagi po ng mga pagdinig ang pagkuha po ng mga ebidensya. Make no mistake, Madam Chair, the committee will fulfill its constitutional mandate to conduct hearings in the context of impeachment. More importantly, make no mistake, we will receive evidence during these hearings. The subpoenas of all the witnesses and documents will be issued. The subpoenas on the audit reports and congressional records will be issued. The subpoenas on the SAL-ends, on the bank records, on the tax documents, on the businesses, corporate records of the Duterte Carpio couple and their business interests placed in the SAL-ends of 2024 will be issued. We will fulfill this mandate today, Madam Chair, until the very end of these proceedings. Yun lamang po. Maraming salamat.
Just for the record, the use of mini trial by some members of the Justice Committee is intended only to make a distinction between the proceeding before the Justice Committee and the trial which will happen in the Senate. Let us always be reminded that our parameter in our hearing proper is the determination of probable cause only, which means the justification to be able to proceed to trial. Again, we are not yet determining the guilt. We are not holding trial. This is just a clarificatory hearing for the purpose of determining probable cause, which will allow us to proceed to trial in the Senate.
Madam Chair.
That is for the record. The
Madam
Honorable
Chair.
Ko.
Madam Chair.
Madam Chair, a comment.
The Honorable Ko and then the Honorable D.S. Puno.
Madam Chair, also for the record, there is a statement released by the Office of the Vice President, echoing the parts of the letter issued by counsel, and again using the word quote-unquote mini trial. Madam Chair, on the record, I'd like to contest and express my grievance on the use of the word mini trial. What is happening on the floor, Madam Chair, is determination of probable cause. It is a different proceeding that if you also provide equivalents in how we do this in the judicial proceedings, clear naman po ang distinction ng ginagawa ng Office of the Prosecutor. And kapag nahanap na po yung probable cause na yon, magpo-proceed na po sa trial sa korte. For me, Madam Chair, it is irresponsible to muddy legal concepts so as to create a reason para po hindi mag-appear and even defeat the capabilities of this committee to talk about evidence, pleadings that is provided and may avenue naman na pinapadaloy under our House rules. So, Madam Chair, I'd just like to put on the record yung grievance on the use of the word mini trial. Thank you, Madam Chair.
Thank you. The Honorable D.S. Puno.
Thank you, Madam Chair. I refer back to the comment earlier by Congressman Diokno, which I think is very important, that we try to be sensitive to any actions that the committee takes that might open us to questioning on the higher judicial levels. We are in a hearing today. Hearings usually result in committee reports. Committee reports that will not have a judgment, that will not have any statement on the true veracity of any evidence that is presented here, because that is the work and job of the Senate, in my belief. So the final report that comes out is not a decision, it is not a judgment, it is a committee report that is forwarded to the Senate and recommending a trial. So I believe that the distinction between whether we are having a trial or not should begin there. And that is where we should rest it, not on the dictionary meaning of trial and so on and so forth. So the use of these terms, while sometimes unfortunate, does not result in nullifying the importance of these proceedings. So even the evidence that we review here, we will examine so that we do not send to the Senate meaningless evidence. It must be evidence that is germane to the complaints that have been filed, and it must be evidence that we have verified to be real facts and not just allegations, not just versions of the truth, but something that we all know is actually the truth, because why would we send it to the Senate if we do not believe that that is the case? So I believe that if we clarify this in the course of our proceedings, that we are not judging any testimony, but merely verifying it for purposes of accuracy, relevance to the complaint that has been filed, and so on, and come out with a committee report in that manner, I don't think that this committee can be accused of conducting a trial, Madam Chair.
Madam Chair.
The Honorable De Lima first, and then the Honorable Rodriguez. Rodriguez George.
Yes, Madam Chair, just a brief reaction to the manifestation of the Honorable Representative Puno. Just to be very clear, what will be transmitted to the Senate is not the committee report. What is to be transmitted to the Senate is the articles of impeachment already. The committee report from this committee will be transmitted to the NBank for consideration of the recommendation, for the consideration and approval of the recommendation of this committee, whether probable cause exists or not. So let's just be very clear about it. And Madam Chair, I noticed that the ground rules, the guidelines distributed to us does not yet reflect the amendment. So if we can have, please, the
The
copy
committee
reflecting-
secretary is directed to reflect or include the amendment that was approved already in the approved ground rules.
Thank you.
Are you finished with your manifestation, Honorable De Lima?
Madam Chair, another point. Can we have a confirmation from the committee secretariat that indeed Respondent Sara Duterte and her counsels were duly notified of today's proceedings? Second, if so, is there any communication or anything, a pleading, a communication filed or submitted to the committee secretariat saying categorically that they are not appearing in today's hearing or in today's proceedings? And another question is there also any communication or any submission made from their camp explaining the absence of Respondent Sara Duterte? Because aside from the letter put on record by the Honorable Terry Ridon about questioning the proceedings under the erroneous premise that what is being conducted here is trial on the merits, is there has been statements, pahayag, from Sara Duterte. I think this was circulated already to media. Let me just point out one important statement here. It's a pahayag from the Vice President of the Philippines, Sara Duterte, dated today, March 25. The second to the last paragraph says, "Naisumit ko na ang aking answer ad cautelam. Sa ngayon, wala nang dapat pang gawin ng komite, kundi ibasura ang mga reklamo dahil sa malinaw na kakulangan ng ebidensya." Is this an indication clear enough that she is waiving her right to participate in our proceedings? So I just wish to have that confirmation of the committee secretariat as to whether there's been any formal communication saying that they will not, whether she or by her counsel, will not participate in the proceedings before this committee henceforth.
The committee secretariat is directed to report to the committee the fact of having sent the notice of today's hearing to the respondent, and whether there is a communication or a document filed in relation to that invitation, as well as the same letter which was earlier manifested by the Honorable Ridon. And if there are any other documents received from the respondent, The committee secretariat is likewise directed to report to the committee. Let's begin with the notice sent to the respondent. Comsec, please.
Yes, thank you, Your Honor. The invitation for Vice President Sara Duterte to attend today's initial hearing was sent by electronic mail on March 19, 2026 at 10:25 a.m. It was acknowledged by, it was received March 19, 2026, 12:34 and acknowledged by the Central Records Unit of the Office of the Vice President. The invitation for two Nervasa and Salazar, counsel for Vice President Sara Duterte to attend today's meeting was emailed on March 19, 2026, 10:21 a.m., received March 19, 2026, 1:45 p.m., acknowledged by Fortune Nervasa Salazar. As far as any communication from the Office of the Vice President manifesting that she will not attend today's initial hearing, the only communication we received with respect to that is the letter from her counsel, Fortune Nervasa and Salazar. That's all, Your Honor.
Any comment from the Honorable De Lima?
Thank you, Madam Chair. It's very unfortunate that the respondent herself is disrespecting the proceedings before this committee. At the very least, she should have manifested formally that she will not be appearing before this committee, and rather than just issuing statements before the media, because that letter submitted by her counsel, the Fortune Law Office, is not yet very clear there. Are they appearing or not? Show respect. They cannot just assume that this is going to be a trial, because it's already clarified that it is not full-blown trial. This is not trial on the merits, but simply akin to preliminary investigation. With, of course, right to counsel, right to appear, right to assist the clients, and right to submit clarificatory questions to the Honorable Chair. So this is disrespect, another manifestation of her affront the constitutional process. I remember what the Honorable Chair cited earlier in her opening remarks. There's this quote from former Supreme Court Justice, I think it's Noel Tiham, not Antonio Tiham, as stated earlier, about the fact that failure to appear, failure to participate in the impeachment proceedings, it's itself a betrayal of public trust, because this is a formal constitutional process that everyone is expected to respect, especially the parties like the respondents. So it is very unfortunate that we have this mindset again, this attitude on the part of the respondent, showing disrespect and affront to the constitutional process of impeachment. Thank you.
Thank you. Now the Honorable Rog Gutierrez.
Thank you, Madam Chair. Madam Chair, I believe the Honorable De Lima has made some good points, and we were actually moving on with the discussion. But I just wanted to go back po, just a short manifestation on dun sa issue ng mini trial, because this representation agrees with our colleagues here today that I think we should confront, I think was the term used, this framing of what is going on here today. Kasi, Madam Chair, we take exception to this because I think it does not have any legal effect the way that it was called a mini trial. If ever even it was mentioned in passing, I would assume. It was never in any official memo, but it shouldn't have any legal effect. No amount of nomenclature can change the proceedings that we're having here. And actually, I believe, Madam Chair, what should be controlling is the letter that actually this committee has submitted to the party of the respondent. And I believe we have here, it is reflected in the letter, March 19, 2026, letter invitation to the Vice President at the March 25, 2026 committee hearing intends to discuss the Saballa and Cabrera impeachment complaints, as well as administrative matters. This includes the setting of ground rules, acting on request for subpoena, scheduling hearing dates, identifying witnesses to be invited for the next hearing, to ensure efficient and orderly proceedings. These, Madam Chair, are matters germane precisely to the functions of the House as that body in which the impeachment proceedings are to be initiated. This is not in any way close to a trial, even if we call it a trial tanggalin na po natin yung mini doon. Sabihin natin, we called it a trial. What we're having here today is very far from that. As mentioned, I think it was Justice Carpio who once mentioned in a concurring opinion that, and it has been thrown around here a lot, no? It is akin to a preliminary investigation. And very clear, if we are even to compare to that under Rule 112, Section 3, Paragraph E, they have their actually clarificatory hearings. So no matter any which way that we call this proceeding, very clear po na this hearing that we're having, if it's going to be considered akin to that, is nowhere near an actual trial by any judicial body. So I think, Madam Chair, we really have to dispel that framing na this is a mini trial or a trial. It's very far from the truth of what is going on here. And I think si Deputy Speaker Puno made some very fine points na what the goal of the hearing that we're having here is very different. In fact, what will be presented here will be different from what will be presented in a trial, should it proceed to that. So, Madam Chair, I just want to, again, manifest, make it clear, I join our colleagues in debunking this mini trial categorization. And in fact, what we're doing here is constitutionally mandated. I believe it was mentioned very clearly. There is the provision that it is only after hearing, and a majority vote of all its members that committee shall submit its report to the House within 60 session days from such referral. This is about the constitutional provision on impeachment po, Madam Chair. So very clear, we're all moving, this procedure is moving within the pace as provided by the Constitution, as you know, clarified by the Supreme Court in this most recent ruling. So again, Madam Chair, I join our colleagues. Thank you.
If there are no other manifestations on the letter sent by the councils of the respondent, we shall proceed to the next matter.
Mr. Chairman.
The Honorable Vice Chair Dumogan and then the Honorable Rufus.
Thank you, Madam Chair. What is important to me is notice had been sent to respondent in her counsel, and there is conclusive proof of receipt. Hence, this committee has complied with the element of due process. Unfortunate, that has already been said, she does not recognize the proceedings in this committee. The most important, you were duly notified of today's proceedings, but did not appear. Thank you, Madam Chair.
The Honorable Rufus Rodriguez.
Madam Chair, if I was so disappointed by the answer, consolidated answer ad colteram, I am really totally dismayed by this letter sent by the lawyers. We have here 6 lawyers who has submitted a letter to the Honorable Chairperson, Jervil Luistro, that we have no jurisdiction to conduct this hearing, which they term as mini trial. Madam Chair, in the first page of the letter, March 24, 2026, it says, the Constitution vests the authority and power to conduct trial solely in the Senate. Clearly, what applies here is the constitutional provision that in the impeachment proceedings, we will have a hearing. It is not a trial. That is very much clear under our Constitution. They are citing here Section 3(8), Article 11 of the Constitution, the state shall have the sole power to try and decide all cases of impeachment. That is right. But we are governed not on the hearing by the Senate, but we are governed by the proceedings on impeaching to find out probable cause. Then, Madam Chair, in this letter, the second page, it says, the same, Article 3(2)(11), the same does not give the committee any power or jurisdiction. Can you imagine that? How can they be able to support this allegation that the committee has no power or jurisdiction to conduct any form of trial, mini or full-blown, because precisely we are not having a trial here on the merits, but only, Madam Chair, on a hearing to determine probable cause. And then, it also says that it is basic that all rules must not contravene. We are not. The committee is not contravening the Constitution nor our rules or any law for that matter. And then finally it says, Madam Chair, that on the ground they're saying that we have no authority and jurisdiction on the ground that the committee and or the HOR as well as any of its members lack jurisdiction to conduct any form of trial or exercise of its incidents. Any law student would know that precisely our committee has the power to hear on finding probable cause by the two complaints where we found sufficiency in form, substance, and grounds. Therefore, I move that we issue an order traversing these particular erroneous allegations in this letter. Erroneous because they are the ones contravening the Constitution. The lawyers of the Vice President are the ones contravening our rules of impeachment. But then, in that letter, we invite them again to appear in the next hearing because we are always mindful of giving due process. So move, Mr. Chairman. Let us answer this by this committee.
Second.
We should answer that these are all erroneous and is not in compliance, is against the Constitution itself, which they are citing. And then be giving them due process. I am disappointed, Madam Chair. This is the chance of the Vice President. In their answer, they did not put forth. I thought it was a strategy that in the hearing, they'll be able to appear. Although, Madam Chair, I don't agree that we should have the Vice President appear here, but counsel should appear and be able to traverse all the 6 grounds of the 3rd complaint and the 5 grounds of the 5th complaint. So I move that we issue an order traversing this, saying that these are all erroneous and that they, in spite of their erroneous interpretation of the Constitution, they are invited to the next hearing if they so mind, because it's clear, our ground rules are clear, the lawyers are
May
able
we
to-
be clarified on
Yes.
the purpose of your motion of inviting the lawyers in relation to the letter that they sent to us?
Also that, and probably, but no, Madam Chair, very clearly, the letter has no basis in law, on the Constitution, and our rules. We don't have to let them here to explain. I'm saying that we should be able to tell the lawyers that this is really a scrap of paper that they have submitted to this honorable committee. It's an insult to the committee, if this is what they want. And so therefore, we have an order from the committee for them to tell them that they are wrong and that they are invited in the next hearing so that we continue to try to give due process to the Vice President, which we wanted precisely to have her side on these grounds. Thank you.
Your motion, Honorable Rodriguez, is to invite the lawyers to answer to the committee about the erroneous impression that they're giving about the proceeding of the Justice Committee. Is that your motion?
No, not anymore. They have already stated this. What I'm saying is that we have an order denying this manifestation and putting our reasons why their letter dated March 24 has no basis in the Constitution, the rules, and the law. And then at the same time, invite them to attend the next hearing so that if they're minded.
We are
to send
inviting the parties and the councils every time we have a hearing.
Chair, but in this case, they are saying that they do not recognize our jurisdiction. And so we're telling them that please come and recognize it because your premises here is totally unfounded and baseless. Thank you.
Right. So there is a motion to issue an order
Madam Chair.
or an answer to the letter belying all the erroneous allegations contained in the letter of Fortuna Narvasa. Do I hear a second?
Madam Chair, it is not, we do not answer. We order. So it will not be, the committee will not answering anybody. It will be an order because we have the jurisdiction to order by stating that they have no basis and they are invited to appear. Thank you,
Madam
but
Chair,
it depends.
There
on the
is a
chair.
motion to issue an order to the councils of the respondent to attend in our subsequent hearings because all their allegations are erroneous. I am
Amendment to
pertaining to the
motion.
letter sent by Fortuna Narvasa.
Amendment to the motion, Madam Chair.
The Honorable D.S. Puno is recognized.
Yes, may I recommend that in the manifest in the amendment that we state that this matter was discussed at this hearing and found to be defective. and erroneous. So I think that those statements of Representative Rodriguez should be included in the order, and then the invitation. But I think we should make it clear that it was discussed, just so that it's not made to seem later on that it was dismissed without due deliberation here.
Madam Chair, may I?
Is
just,
this in relation also to the motion? The Honorable Zia Alonto Adjong.
Before we act on the motion, Madam Chair, just for the public consumption, because our kababayans are watching us right now, the order as proposed by Congressman Rufus Rodriguez should not be taken as something for this committee to treat the lawyers with an equal footing, because the legitimacy of this process does not rely on the acceptance or recognition of these lawyers, or anyone for that matter. We are exercising our constitutional duty to proceed with the investigation, with the hearing as we are conducting right now. Para po sa kaalaman ng karamihan, yung sinasabi po ni Congressman Rufus Rodriguez is not really in response to put them in the equal footing as though the lawyers and this committee is exchanging ideas or opinions. Because number one, hindi po nakasalalay ang integridad, ang proseso at legitimacy ng hearing na ito sa acknowledgement, recognition ng sino man or kanino mang parte, Madam Speaker.
Madam Chair, the letter was submitted
The Honorable D.S. Puno.
to the chairperson as chairman.
It is addressed to the
addressed to the
chairperson,
chairperson as chairperson of the committee.
That's correct.
So I think at the very least we should manifest that this has been brought out to the members. It has been read by Representative Ridon, and it has been commented upon by Congressman Rufus Rodriguez. That does not make them and give them equal status with us. It merely tells them that we are fair, and we have taken this into consideration and actually found their manifestations and their letter to be defective in substance, no, and in what
Madam
they
Chair.
allege.
Madam Chair.
The Honorable Jokno.
Yes, I have some serious reservations about using the term order because it could be twisted and made to appear that we are acting like a court. I would agree that we should respond to the letter. Since it was addressed to the chair, perhaps the chair could synthesize all of the discussions made today. And if I may add on that point, we are exercising a constitutional duty today and in succeeding hearings to conduct a hearing. And we have gone through all of the form and substance. We have already made the finding that there's sufficient ground to proceed with the impeachment proceedings. So what else do we have to do except to look at the evidence? Yan po yung tungkulin natin. And it must be clear to the public and to the lawyers of the Vice President that that is what we are doing today. Thank you.
So the suggestion of the Honorable Jokno is instead of an order of the committee, that the chairperson answer the letter of Fortuna Vasa. Let's hear the comment of the proponent, the Honorable Rodriguez.
Madam Chair, the issue has been brought to the committee. It's not anymore the letter is addressed to you, but precisely the issue has been discussed by the committee proper. And so it therefore should be an order, not a singular letter from the chairman, so that it is clear that that is the position of the committee, that we're ordering that they appear and that we are saying in that order that all their allegations, all their statements here are erroneous, have no basis in the Constitution, in law, and in fact. Thank you, Madam Chair.
Any other comment from the Honorable Jokno? Are you now amenable to the original motion of the Honorable Rodriguez?
I'm very concerned, Madam Chair, with the use of the word order. Because I anticipate that the councils, based on what I read in this letter, it would appear that they are looking for reasons to question the committee before the courts. And if we use that term, they can use it against us and say, see, earlier you mentioned mini trial, now you are ordering us. And that will, then they can use that as a ground for questioning the committee. In fact, Madam Chair, they are entitled to their own opinion about what we are doing today. If they believe that we don't have jurisdiction, that's up to them. But I believe that we must just do our duty, fulfill what the Constitution commands, and hayaan na natin sila kung yan ang gusto nilang opinion. It's very clear from our discussion that we are not doing what they claim we are doing, that we are not going outside the jurisdiction, but rather following what the Constitution provides.
Chair, final point, Madam Chair.
To resolve the disparity between the motion of the Honorable Rodriguez and the suggestion of the Honorable Jokno, may we just release a letter in response to the letter of Fortuna Basa from the Justice Committee and not from the chairperson of the Justice Committee, if that would be acceptable to these two gentlemen?
First of all, just 2 points. First point, even in preliminary investigations, the prosecution orders clarificatory questions. Order does not mean that it will only come from the court or from the trial, the Senate, for example. Order is because we have jurisdiction. There is an order issued in preliminary investigation under the rules on criminal procedure that precisely order for there to appear to answer clarificatory questions by the prosecution. And so that fear of an order not being, it will cause some comments from the other party. It's not to me. It's not very at this point. It's not something that we cannot do. We have to therefore emphasize that as Committee on Justice is hearing. We are not having trials, but we are hearing for probable cause. And because they have sent this letter, which we find to be that they are not going to appear anymore because of no jurisdiction, an order requiring them to appear by stating also that their basis for not appearing, not recognizing the jurisdiction of this court has no basis in the Constitution, in law, and in fact. Thank you, Madam Chair.
I understand that the argument of Honorable Jokno is predicated from the fact that we're being framed to be conducting a trial, when in fact this is just a clarificatory hearing. So for purposes of caution, no? In order not to give them any opportunity to place us in a wrong impression of not following the Constitution and the rules, I don't see anything wrong about answering instead of issuing an order, if that will be acceptable to the Honorable Rodriguez.
Madam Chair.
The Committee on Justice can respond to the letter in its capacity as the committee and not me as the chairperson.
Madam Chair, I always agree with the chair. Thank you.
Madam Chair.
Same manifestation, Madam Chair. We agree.
Madam Chair.
The Honorable Tino.
Well, sumasang-ayon po ako sa naging resolusyon dun sa
And that is the letter of the Justice Committee.
Oo, particular dun sa hindi nagagamitin
Responding
ng...
point by point the erroneous allegations in the letter of Fortuna Basa.
Opo, na hindi nagagamitin yung salitang order, magpapadala ng sulat. Pero malinaw din po sa rules para lang i-put also on the record that the committee, according to the rules of procedure, that the committee shall have the power to issue compulsory processes for the attendance of witnesses and the production of documents and other related evidence. So just for the record, meron pa rin namang kapangyarihan.
That is correct.
Na mag-issue ng mga order, compulsory orders,
That is correct.
ang committee ito. Yun lang po,
Just
Madam
because
Chair.
this is a formal proceeding, may I solicit the necessary motion pertaining to the answer
Chair.
which the committee will release in response to the Fortuna Basa letter?
Madam Chair.
Madam Chair.
I defer to the position already expressed by the Honorable Chair with respect to just responding through a letter. But actually, my personal view is that we need not dignify that letter from the lawyer of
That's
the
another
respondent.
concern.
Yes, let's not dignify that. They're expressing their own position. It's not yet, it has to do, we can ignore that because it's wrong. It's erroneous. The position raised there is erroneous. And until and unless they really formally raise the matter, they formally raise the issue before this committee, then we need not rule on it. We need not issue anything. But I defer again. I defer to the position of the Honorable Chair and agreeing with the proposal of the Honorable Chair Jokno that we can only respond through a letter containing our arguments, our counter-arguments on the position expressed in that letter. But as I said, we can actually ignore that and let's not dignify that. Thank you.
To finally resolve our proper action in relation to the letter of Fortuna Narvasa, may I hear the necessary motion on the letter which the Committee on Justice will issue? If you are not in favor to answering that letter, then perhaps you should not vote in favor of this motion. Because Honorable De Lima is now arguing that we should not dignify with an answer the letter containing erroneous allegations about the jurisdiction of the Justice Committee.
Madam Chair.
The Honorable
Yeah, Madam
Adjong.
Chair, I was earlier, I was actually eager to second the motion of Congressman Rufus Rodriguez. But upon hearing the observation and the recommendation of Congresswoman De Lima, I think that would be much proper because earlier, Madam Chair, I was actually explaining to the committee that we should not give them any chance of maybe, attributing we're on the same standing or the same footing because this hearing does not rely on the acknowledgement or recognition of the lawyers from the law firm. So I guess it would be proper, I think so, for my own humble opinion, that we should not, again, if I may also use the statements of Congressman De Lima, dignify, and instead exercise this committee's mandate because we also have the options to either making them order, as cited, pwede tayo mag-issue ng mga orders pala, as cited by Congressman Tino. So I think it would be much proper because we can still, maintain the integrity of this committee by simply not giving too much attention to their, to the position of this law firm. So I would suggest that we take consideration of the suggestion of Congresswoman De Lima not to dignify this letter.
For the guidance of the Justice members, our parliamentary status, there was a motion to issue an order. The same has been withdrawn by the proponent, the Honorable Rodriguez, by his conformity to the chairperson. Now there is a pending suggestion about issuing a letter from the committee to address the erroneous allegations in the letter of Fortuna Narvasa. But we are hearing another opinion not to dignify with an answer the erroneous allegations in the letter of Fortuna Narvasa. If there will be no motion, then it will be perceived and interpreted as no action will be taken to the answer of Fortuna Narvasa letter. Therefore, the chair announces that the
Madam Chair.
committee will not take any action to the letter. Let it be so long as we are following the Constitution and the rules of impeachment of the House of Representatives. So ruled. Now we proceed to the next matter. Is it about the letter?
Yes,
It has been ruled upon Vice Chair Dumogan.
Thank you, Madam Chair.
We have a lot of things to discuss for today's hearing,
Well,
with your indulgence.
You have already ruled, but I was about to suggest, because the most important is the tenor of our letter. We can say,
We are not issuing a letter because nobody moved to issue a letter.
because there's some, despite your letter, we are inviting you to the next hearing. We can see it that way.
Nevertheless, the lawyers and the parties are always invited, notwithstanding the letters of non-appearance, notwithstanding the letter that they are not recognizing our jurisdiction.
My worry, Madam Chair, is if we do not also respond to that, they are directly attacking us. It's not, to me, it's not good. Why can we not just say, despite your accusation, we are respectfully inviting you to the next proceedings.
Madam Chair.
Vice Chair Dumogan, we take note of your manifestation, but this issue has been ruled upon. Now I proceed to the next matter for our today's
Madam
hearing.
Chair.
That
Madam
is
Chair.
the action. Is it about the letter?
Madam Chair, since...
Honorable Marcoleta, is it about the letter? Because the same has been ruled upon.
Ma'am, since the due process has been mentioned several times in today's hearing, I have something to say about it.
Is it
Due
about the
process.
letter?
Somehow, somewhat related to the letter, but not confined to the letter. Let's not be confined to the... We're talking about due process, Madam.
All right, you are
If I
recognized.
may be allowed, just 2
For the
points.
guidance of the members, our colleague is a non-member. Nonetheless, he is allowed to manifest. You may proceed.
Thank you, Madam. I respectfully rise for a brief manifestation for the record. Madam Chair, during the last hearing, I was advised by the Honorable Chair to peruse the rules because I raised the terminology sufficiency and grounds, which was mentioned, I think, 16 times by the Honorable Chair. And I have gone over the rules very diligently, and the rule provides that the committee shall determine whether the complaint alleges sufficient grounds for impeachment. Nowhere in the rules you can find sufficiency in ground. Ang aking pong opinion, Madam Chair, pag binago po natin o we alter the terminology, it will reap a different meaning or a different consequence. When we say we're just determining alleged sufficient grounds, we are just testing the allegations. Pag sinabi nating sufficiency in grounds, we seem to be weighing the evidence. So I just implore the wisdom of the Madam Chair to stick to the precise wording as stated in the rules. Yun lang, that's my number one point, ma'am. And
You have other manifestations?
yes, ma'am.
You may proceed.
Number two, Madam, I have questions as to how the process of determining alleged sufficient grounds was achieved during the last hearing. How did we arrive at the determination? Because as far as I can recall, the Honorable Rufus Rodriguez suggested that we deliberate on the grounds, ground by ground, because the complaints are nothing without the valid grounds from which its own merit should be anchored. So I agree with the view of the Honorable Rodriguez that we should have deliberated the two complaints ground by ground in order to arrive at a more judicious determination. And ang narinig ko lang po during the last hearing are perfunctory recital of allegations by the endorsers. So it would appear that this was just a peremptory declaration of sufficient grounds and nothing more. Yun lang na po. Ang aking pong pakiwari, we should be not abbreviating due process because the ruling on Duterte versus House of Representatives stated that due process and the constitutional limitations should always be present at every stage of the impeachment process. That's all, Madam Chair.
The committee notes all the manifestation of the Honorable Marcoleta. Now we proceed to our pending motions and or requests before the Justice Committee. The Honorable Joel Chua is recognized.
Thank you, Madam Chair. Madam Chair, the committee has received a letter dated March 5, 2026 on even date from Honorable Chel Jokno, where he moved that subpoena duces tecum be issued for the following. Number one, duly certified copies of all the records of the NBI's investigation into the threats made by Vice President Sara Duterte against President Ferdinand Bongbong Romualdez Marcos Jr., First Lady Luis Lisa Cacho Araneta Marcos, former Speaker of the House, Ferdinand Martin Gomez Romualdez Sr., and certified true copies of all documents and photographs gathered in the course of the above-mentioned investigation. And number two, duly certified true copies of the Statement of Assets and Liabilities and Net Worth of Vice President Sara Zimmerman Duterte for the years 2022 to 2025 inclusive, 2007 to 2013 inclusive, and 2016 to 2022 inclusive. Madam Chair, considering that the requested documents are relevant and material to the impeachment proceeding, I so move that subpoena duces tecum be issued pursuant to the letter dated March 5, 2026. So move, Madam Chair.
There is a motion to issue subpoena duces tecum to the NBI with respect to the records of its investigation into the threats made by Vice President Sara Z. Duterte against President Ferdinand Bongbong Marcos Jr., First Lady Marie Luis Lisa Araneta, and former Speaker Ferdinand Martin Romualdez, as well as the certified copies, true copies of all documents and photographs gathered in the course of the above-mentioned investigation. Similar motion is made with respect to the certified true copies of the Statement of Assets and Liabilities and Net Worth, that is SALN, of Vice President Sara Zimmerman Duterte for the year 2022 to 2025 inclusive, 2007 to 2013 inclusive, and 2016 to 2022 inclusive. The second motion is directed to the Ombudsman. May I hear the confirmation of the Honorable Chua? For the SALN.
Yes, Your Honor.
The second subpoena is directed to the Ombudsman. That is with respect to the SALN of the Vice President. Do I hear a second? The same has been seconded.
Madam
Is
Chair.
there any objection?
Madam Chair,
The Honorable Rodriguez.
we cannot
Are you objecting?
manifestation first before I would make my. We cannot have two motions being proposed at the same time. Practically, there should be two motions. The first motion are the NBI findings. The second is the SALN. We should go one by one, Madam Chair, because I am going to agree to vote yes to the first one. The second one, it is a fishing expedition. It is not. There are no ultimate facts on the SALN of the Vice President. So I will vote no. I will object to the second one. The first one goes, Madam Chair.
May
So
we
should
hear
divide-
from the...
We should have two motions instead of only one. Two subject matters. Under our rules, in the rules of court, motions should only be on one subject matter.
May we hear from our proponent? The Honorable Rodriguez is suggesting that there should be one motion per subpoena.
Yes, I move that we vote
Would you
on,
like to amend your
yes,
motion?
I will amend my motion with respect to the. I move that we issue subpoena duces tecum to be issued to the for the duly certified copies of all the records of the NBI's investigation into the threat made by the Vice President Sara Duterte against President Ferdinand Bongbong Marcos, and certified true copies of all documents and photographs gathered in the course of the above-mentioned investigation. And so move, Madam Chair.
There is a motion to issue a subpoena to the National Bureau of Investigation with respect to the records of investigation of threats made by the Vice President, to the President, to First Lady, and to the former Speaker. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the motion is approved. The committee secretary is directed to issue the necessary subpoena. The Honorable Chua.
Madam Chair, with respect to the second subpoena, I move that we issue subpoena duces tecum to the Office of the Ombudsman for the issuance of the duly certified true copies of the Statement of Assets and Liabilities and Net Worths of the Vice President Sara Zimmerman Duterte for the years 2022 to 2025 inclusive, 2007 to 2013 inclusive, and 2016 to 2022 inclusive. So move, Madam Chair.
There is a motion for issuance of subpoena to the Ombudsman with respect to the SALN of the Vice President from 2022 to 2025, 2007 to 2013, 2016 to 2022. The same has been seconded. Is there any objection?
Madam Chair,
Is that an objection,
I
Honorable
object.
Rodriguez?
I object. This is now a clear fishing expedition against the Vice President. Thank you.
Considering that the motion has been objected to, we shall proceed to divide the House. Justice members, please be ready to vote. Those who are in favor of the motion for issuance of subpoena to the Ombudsman for the production of SALNs from 2022 to 2025, 2007 to 2013, and 2016 to 2022. Please raise your right hand. You may now put down your hands. Those who are not in favor of the motion, please raise your right hand. You may put down your hand, Honorable Rodriguez. Those who abstain, please raise your right hand. That concludes the voting. Secretariat, the result, please. With 34 votes in the affirmative, 1 vote in the negative, and 0 abstention, the motion is granted. The committee is directed to issue subpoena duces tecum to the Ombudsman for the production of the SALN of the Vice President corresponding to the period of 2022 to 2025, 2007 to 2013, and 2016 to 2022. So ordered. The committee is likewise in receipt of the manifestation from the Honorable Congresswoman Laila De Lima. May we hear from the Honorable De Lima.
Thank you, Madam Chair. This representation confirms that as an ex-officio member of the Committee on Justice and as an endorser of the Saballa et al. Complaint against Vice President Sara Duterte, I filed yesterday, March 24, with the Committee on Justice and with a copy furnished to respondent by the committee secretary, a request for the issuance of subpoena duces tecum and ad testificandum for the following 5 individuals, 5 resource persons and or witnesses. 1, Attorney Gloria A. Camora of the Intelligence and Confidential Funds Audit Office of the Commission on Audit to produce, identify, and authenticate official COA audit records, including liquidation reports, disbursement vouchers, certifications, and related submissions of the Office of the Vice President and the Department of Education pertaining to the disposition of the confidential funds for the years 2022 and 2023. In my letter, Madam Chair, there's a long list actually of those copies, of those documents, the original copies of which we are seeking to be produced via subpoena from Attorney Gloria Camora of the Intelligence and Confidential Funds Audit Office of the Commission on Audit. I so move, Madam Chair, to issue subpoena duces tecum and ad testificandum to the named individual or named employee or official of the Commission on Audit.
There is a motion for the issuance of subpoena to Attorney Gloria A. Camora. You mentioned the Honorable De Lima, officials from COA. Other than
Attorney Gloria Camora.
Other than Attorney Camora, are there any other officials you would
Just
like to be
Attorney Gloria
subpoenaed?
Camora for the moment. Attorney Gloria Camora of the Intelligence and Confidential Funds Audit Office of the Commission on Audit, because she's the custodian of these COA records and documents, including liquidation reports, disbursement vouchers, certifications, and related submissions of the Office of the Vice President and DepEd pertaining to confidential funds.
There is a motion for issuance of subpoena duces tecum and ad testificandum to Attorney Gloria A. Camora with respect as well to the documents pertaining to the confidential funds during the alleged period.
Yes, Madam Chair, as I said, it's a long list actually. There are the checks, the disbursement vouchers as listed, proof of submissions, liquidation reports, certifications, accomplishment reports, certifications of various dates, etc. It's a long list as listed in the letter of this representation, the letter request of this representation.
We are directing the committee secretary to provide copy of the manifestation or the request to the justice members. And the same is also adopted in support of the motion raised by the Honorable De Lima.
Madam Chair, discussion. I'd like to have a clarification.
Just for the record, the motion of the Honorable De Lima has been seconded by the Honorable Zamora.
Yes, now
Honorable
discussion.
Rodriguez.
I would like to clarify. Clarification from the proponent, from the movant. Is this the confidential funds of 2022 and then 2023 of the Office of the Vice President and not the Office of the Secretary of the Department of Education? May we know? May we clarify?
There are documents pertaining to the confidential funds of the Office of the Vice President, and there are also documents pertaining to the confidential funds for the Office of the DepEd, Department of Education.
Madam
Because
Chair.
those are grounds number 1 and 2 of the affidavit, of the complaint, the Sabalia et al. Complaint.
Madam Chair, when our distinguished Congresswoman De Lima, she mentioned of 22 and 23 years. In your first motion, when you stated the motion, 22, 23. So that's why I'm getting clarification. Are you now including the DepEd confidential funds? Because your motion is 22 and 23.
22, 2023.
Because the COA has not been able to have a final notice of disallowance on the DepEd confidential funds.
Again, may I?
Yeah, because when I heard you, it was 2022, 2023. That is pertaining to the Office of the Vice President. But then now you're saying, in my clarification, that you are also moving for her to be able to give documents regarding the confidential funds of the Office of the Department of Education where she was secretary. Let us be clarified on that. Are you
Yes,
also
Madam
including?
Chair. With respect to the DepEd, these are also, again, the list is here. With respect to DepEd, there will be accomplishment report dated September 30, 2023, for the period July 12 to September 30, 2023. So there's a covered period, actually, 2022, 2023, and also it's 2023, and the certification issued January 1, 2024. Certification dated December 30, 2023. So covering also the Department of Education.
I will therefore object, Madam Chair, because it is this humble representation's position that under the Duterte versus House of Representatives ruling, only actions pertaining to the impeachable office of the impeachable official can only be the subject matter here. Objection, Mr. Chair, Madam Chair.
The Honorable Rodriguez is consistent
May I
in his
respond to
position
that
since our
objection?
determination of substance. The Honorable
Yes.
De Lima.
Well, that matter was settled already during the proceedings for the determination in substance and also for the proceedings for the determination of whether there are sufficient grounds for impeachment. At any rate, the Honorable Rufus Rodriguez made mention about the ruling of the Supreme Court in the Sara Duterte versus House of Representatives. And it says there, during the incumbency. Yes, it says there, during the incumbency of the impeachable official. Here, the Vice President Now, it doesn't say in relation only to her office as Vice President. Because, you know, she was occupying the DepEd Secretary portfolio in her concurrent capacity as Vice President. Now, you don't distinguish the actions made, especially the anomalous actions, the impeachable offenses made because it's with the department, pertains to the Department of Education. Just to explain it further, Madam Chair, what if the Vice President kills someone? It doesn't say it's in relation to or as Vice President and as DepEd Secretary, but that crime happens during her incumbency as Vice President. She may have two hands, as OVP, as VP, and as DepEd, but she has only one brain. She has one persona. She is the same person. Again, the Supreme Court says, during the incumbency of the impeachable official, but not in relation to. There's a big difference between that, the use of those phrases, during her incumbency and also in relation to her functions or duties as Vice President. So that is my counter-argument
With all due
to the
respect to
position
the
made.
Honorable Dilima and the Honorable Rodriguez, I believe that this issue has been deliberated upon amply during our determination of sufficiency in substance and even in the sufficiency in ground. So with the indulgence of all the members, let us proceed to vote on the motion for issuance of subpoena duces tecum and subpoena ad testificandum with respect to Attorney Gloria A. Camora and all the documents pertaining to the confidential fund in 2022 and 2023, both of the Department of Education and the Office of the Vice President. The same has been seconded. The motion was also objected to. Let us now proceed to vote. Members, please be ready to vote. Those who are in favor of the motion, please raise your right hand. You may put down your hands. Those who are not in favor of the motion, please raise your right hand. You may put down your hand, Honorable Rodriguez. Those who abstain, please raise your right hand. That concludes the voting. Committee Secretariat, result please. With 29 votes in the affirmative, 1 vote in the negative, and 0 abstention, the motion is granted. The committee is directed to issue the necessary subpoena duces tecum and subpoena ad testificandum to Attorney Gloria A. Camora, and with respect as well to the production of pertinent documents on confidential fund of both the DepEd and the Office of the Vice President in 2022 and 2023. So ruled. Honorable Dilima.
My second motion is to issue subpoena duces tecum and ad testificandum to Mr. Ramil Lagunoy Madriaga to produce, identify, and authenticate his affidavit dated November 29, 2025, which is Annex A of the complaint in the Sabalia et al. Complaint, and any other documentary or object evidence in his possession, and to testify thereon. This is with respect to receipt on the receipt, handling, and distribution of the confidential funds. It's very clearly alleged in the complaint of the Sabalia et al.
There is a motion raised by the Honorable De Lima to issue subpoena duces tecum and subpoena ad testificandum to Ramil Lagunoy Madriaga and for the production of affidavit dated November 29, 2025, as well as any other evidence in his possession. The same has been seconded by Vice Chair Dumogan. Is there any objection?
Madam Chair, objection because again, there is a statement here in the third column that it's also his testimony on the DepEd's confidential funds where we have no jurisdiction. Objection, Madam Chair.
Considering that the motion has been objected to, we shall now proceed to vote. Committee on Justice members, please be ready to vote. This is on the motion for the issuance of subpoena duces tecum and subpoena ad testificandum to Ramil Madriaga, as well as for the production of his affidavit and any other evidence in his possession. Those who are in favor of the motion, please raise your right hand. You may put down your hands. Those who are not in favor of the motion, please raise your right hand. Thank you, Honorable Rodriguez. Those who abstain, please raise your right hand. That concludes the voting. Committee Secretariat, result, please. With 29 votes in the affirmative, 1 vote in the negative, and 0 abstention, the motion is hereby granted. The Committee on Justice is directed to issue the necessary subpoena duces tecum and subpoena ad testificandum to Ramil Madriaga and for the production of his affidavit dated November 29, 2025 and any other evidence in his possession. So ruled. Honorable De Lima.
My third motion is for the issuance as well of subpoena duces tecum and ad testificandum to Attorney Cynthia Viñas Pantonal, the notary public who notarized the affidavit of Mr. Madriaga, to identify and authenticate the due execution and notarization of Mr. Madriaga's affidavit.
Second, Madam Chair.
There is a motion to issue subpoena duces tecum and subpoena ad testificandum to Attorney Cynthia Viñas Pantonal, as well as for the production of the original copy of the affidavit of Mr. Madriaga dated November 29, 2025. Do I hear a second?
Second,
The same
Madam
has been
Chair.
seconded. Is there any objection?
Madam Chair, objection.
The same objection is
consistent.
registered by the Honorable Rodriguez. Let us proceed to vote. Justice members, those who are in favor of the motion, please raise your right hand. You may put down your hands. Those who are not in favor of the motion, please raise your right hand. You may put down your hand, Honorable Rodriguez. Those who abstain, please raise your right hand. That concludes the voting.
Madam Chair, I just stepped out, but I'm voting in favor of the motion as
The
well.
Honorable Jokno is registering his vote in favor of the motion. Result, please. Ulit, ilan? 30 po. Tapos 1. With 30 votes in the affirmative, 1 vote in the negative, and 0 abstention, the motion is granted. The committee is directed to issue the necessary subpoena duces tecum and subpoena ad testificandum to Attorney Cynthia Viñas Pantonal, as well as the production of the original affidavit of Mr. Madriaga, executed on November 29, 2025. So ruled. The Honorable Dilima.
Madam Chair, my fourth motion is also for the production of subpoena duces tecum and subpoena ad testificandum to the custodian of the Archives Division of the House of Representatives to produce, identify, and authenticate transcripts, video recordings, and related records of prior hearings of the House Committee on Good Government and Public Accountability on the Office of the Vice Presidents and Department of Education's disposition of their confidential funds for 2022 and 2023. I so move, Madam Chair.
There is a pending motion for the issuance of subpoena duces tecum and ad testificandum to the Legislative Library Archives Division, House of Representatives, as well as for the production of transcript and video recording of the House Committee on Good Government and Public Accountability on September 18, 2024, September 25, 2024, October 17, 2024, November 5, 2024, November 25, 2024, as well as the production of the affidavit of USEC Gloria Mercado and the envelopes labeled Hope, submitted by Undersecretary Mercado. The motion has been seconded by the Honorable Zamora. Is there any objection? Hearing none, the motion is hereby granted. The necessary subpoena duces tecum and ad testificandum in as far as the Legislative Library Archives Division of the House of Representatives is hereby directed to be issued by the committee. The Honorable Dilima.
Madam Chair, the fifth and last motion for today's proceedings for the production of subpoena duces tecum and subpoena ad testificandum to be addressed to a representative from the Philippine Statistics Authority to produce, identify, and authenticate certifications from the civil registry system, such as the database, the PSA Civil Registry System database on the certificate of live birth, certificate of marriage, certificate of death on several names found in the submissions of the Office of the Vice President and Department of Education, particularly certification dated December 8, 2024 and December 11, 2024. This is to show the recipients of OVP's and DepEd's confidential funds had no birth, marriage, or death records, as well as to identify and authenticate the requested certifications. I so move.
There is a motion for issuance of subpoena ad testificandum to the Philippine Statistics Authority, Carlos P. Garcia, to the Philippine Statistics Authority, or to the representative of the Philippine Statistics Authority, and for subpoena duces tecum with respect to the original copies of the certifications pertaining to PSA verification made from PSA Civil Registry System database on the certificate of live birth, marriage, and death on several names found in the submissions of the OVP and DepEd, particularly the following: certification dated December 8, 2024, and certification dated December 11, 2024. Do I hear a second?
Second.
The same has been seconded. Is there any objection? Hearing none, the motion is granted. The committee is
Chair.
directed to issue the necessary subpoena to the representative of the PSA, as well as for the production of the documents mentioned therein.
Madam Chair, just a manifestation.
The Honorable Marcoleta is recognized.
Thank you, Madam Chair. I recall during the previous hearings, maybe 2 or 3 past hearings ago, I raised the issue of procedural due process when I said that ginanap ng Kongreso ang trabaho na di dapat nila ginagawa dahil ito ay trabaho ng COA. And I was referring to the past hearings made by the Quadcom, or if I'm not mistaken, the Committee on Good Governance. And the chair remarked that wala pong kinalaman ang mga past hearings ngayong hearing ng impeachment ni VP Sara. Pero ngayon po ay tila ginagamit natin at humihingi tayo ng dokumento mula sa mga hearings na yon. So ako po ay nagugulumihanan. Kala ko po ba walang kinalaman ang mga past hearings ng Quadcom o ng Committee on Good Government, pero tayo po ay nagbabalik tanaw at kukuha ng mga dokumento mula sa archives ng hearing na yon. May I be clarified, Madam Chair?
This impeachment proceeding pertains to the fitness to hold public office of our Vice President Sara Zimmerman C. Duterte. That is the reason why manifestations pertaining to the past inquiry of Quadcom and even of the Committee on Good Government was discouraged by the chairperson. Nevertheless, all the manifestations of the Honorable Marcoleta are duly noted by the Committee on Justice. Now we proceed. We have discussed already all the pending matters before the committee, and the chair wishes to reiterate the previously announced schedules for our subsequent hearings. That includes April 14. After this announcement, April 14, April 22, and April 29.
Madam Chair.
The Honorable Tino first, and then the Honorable D.S. Conghon.
Madam Chair, may I make an additional motion for the issuance of a subpoena?
I'd like to make another motion for the issuance of subpoena.
I move that the subpoena be issued to Attorney Michael Wesley Poa in his capacity as the former Chief of Staff of the Vice President and DepEd Secretary from 2022 to 2023. In such capacity, he has very material and relevant information on how the confidential funds in the DepEd were used, and in particular, he had a direct role in the preparation of the accomplishment reports relating to the use of the DepEd's confidential funds, some of which these accomplishment reports have been the subject of the request for subpoena that this committee has approved.
May
So
we
I
hear
so
from
move, Madam
our
Chair.
endorser? Would you like to comment to the motion of the Honorable Tino? He wishes for the issuance of subpoena ad testificandum to Attorney Michael Poa, considering that during that time, he was assuming the position of
Chief of Staff of the DepEd Secretary.
COS
Yes.
of DepEd.
Undersecretary, with the rank of Undersecretary.
Honorable De Lima?
My motion was pertained only to the custodian of those COA audit records, including liquidation reports, disbursement vouchers, certifications, and related submissions from the custodian, the official custodian of the Intelligence and Confidential Funds Audit Office of the Commission on Audit. I won't have any strong objection to that request, since it's related to this item.
All right,
The
so
subject matter of the first motion that I put forth, which was approved by the body.
so the
Thank you.
chair will now act on the motion. The committee will now act on the motion. Is that an objection to the motion of the
Definitely.
Honorable Tino?
I object. Are there documents that the Chief of Staff, Attorney Poa, has signed that he would be a witness to identify? May I ask the proponent?
Before we entertain the objection of the Honorable Rodriguez, let me just formalize that there is a motion raised by the Honorable Tino to issue a subpoena ad testificandum to Attorney Michael Poa, considering that he was the Chief of Staff of the Office of the Department of Education during the alleged period of 2022 and 2023. Do I hear a second?
Second.
The
same has been seconded by the Honorable D.S. Conghon. Now let's hear the objection of the Honorable Rodriguez.
Madam Chair, I could not find nexus borne by evidence or ultimate facts that would now make the chief of staff and lawyer of the vice president to be subpoenaed. In fact, he has entered this appearance as counsel. So I would like to know whether there are documents which he certified or he signed that would make him be able to be invited to be given subpoena to appear in this committee. Otherwise, then we can, just because they are in the office of the vice president, we'll be giving subpoena to everybody there in the vice president's office. So I object, and I would like to know about that. Are there documents that would show that he has been part of these confidential funds?
Yes, Madam Chair, in the third complaint endorsed by the Honorable De Lima, there is a section extensively discussing the role that then USEC POA played in preparing the accomplishment reports pertaining to the use of the confidential funds, where and the complaint cites the transcripts of the hearings of the Committee on Good Governance on this matter, where USEC POA admits that one, he was ordered by the Vice President to submit these accomplishment reports, and also cited in the complaint that the several Army units denied what was claimed in these accomplishment reports.
So we've heard the justification of the Honorable Tino. We've heard as well the justification in the objection of the Honorable Rodriguez. We are a collegial body, so we shall now proceed to vote on the motion
Before
of the
the
Honorable
voting,
Tino.
Madam Chair, I would like the proponent to show to us documents, certifications that had led to the release of these confidential funds. Because we are now already on the hearing, precisely. Are there any? Because if there's none, there is no reason to call him and subpoena a lawyer.
Madam
The
Chair,
Honorable
as I
Tino.
said, I cite the complaint itself, the third complaint. If I may, thank you.
Allegations lang naman yun, wala nga documentary.
Specifically, starting from
The process of utilization of the alleged confidential fund is not confined to the documents.
okay.
There could be actions that contributed to the utilization of confidential fund, which might be covered by the testimony of the possible witnesses.
Okay. Well, starting from paragraph 269 of the third complaint, page 90, there is a reference to former DepEd spokesperson. He was spokesperson as well as chief of staff, Michael Poa, testifying that he received envelopes directly from Vice President Sara herself. So this has to do with the allegation on bribery. And further, and there are other sections as well pertaining to the use of the confidential funds, Madam Chair. If Congressman Rodriguez would want, we can provide, given enough time, Madam Chair.
Oh, Madam Chair, we are now voting, so we should be able to get it if there is. The fact that he's chief of staff and counsel will not, implicate him to be able to have that if there is no document. So I would object to that, Madam Chair.
With the indulgence of these two gentlemen, as to whether or not there's relevance in the presentation of Attorney Michael Coa, will be a question that rests on the judgment of the justice members. We shall now proceed to vote. Those who are in favor of the motion for issuance of subpoena ad testificandum to Attorney Michael Poa, please raise your right hand. You may put down your hands. Those who are not in favor of the motion? Thank you, Honorable Rodriguez. 2, 3. Were you able to count? Those who abstain, please raise your right hand. That concludes the voting. We shall announce the result. With 34 votes in the affirmative, 3 votes in the negative, and 0 abstention. The motion is granted. The committee is directed to issue the necessary subpoena ad testificandum to Attorney Michael Poa. So ruled.
Madam Chair,
The Honorable Jokno.
there is still one more pending incident, I believe, that pertains to the petition that this representation filed with the House, which was referred last Wednesday to the committee. This is a petition under Section 8 of the Rules on Impeachment, which provides that the House may, upon proper petition, provide adequate protection to a complainant or witness if it is shown that the personal safety of the witness is in jeopardy because of participating in the impeachment proceeding. I will no longer reiterate what is contained in my petition, Madam Chair, but if I may just add a few points that I believe are important for the consideration of the committee. Una-una po, para sa kaalaman ng taong bayan, hiniling natin ang proteksyon para kay Ramil Madriaga para makapunta siya rito at magbigay ng kanyang testimonya under oath sa harap ng committee ito. Standard po ito sa sinumang saksi, pero mas mahalaga ito dahil may mga direktang ulat na galing mismo kay Ginoong Madriaga na may panganib sa kanyang buhay. In his own sinumpaang salaysay, sinabi niya, and I quote, "Araw-araw na rin nagsasabi sa akin, delikado na talaga ang buhay mo, seryoso. Ingat Ram, balita ko mataas-taas ang reward money sa iyo, secure mo ang family mo, at iba pa." Sa loob ko ay nakakaramdam ako ng sobrang takot. Ang takot na yon ay hindi lang sa sarili ko, kundi pati sa aking pamilya. Napaparanoid na rin po ako kasi posible rin ito mangyari, nalasunin ako. Halos hindi na ako mapakali, kuminsan at hindi ko maiwasan magduda na rin sa mga fellow PDLs at kahit po mismo sa mga jail officers dahil sa pagsiwalat ko ng issue kay VP Sara Duterte. Madam Chair, these threats have already escalated. According to his affidavit, on March 3, 2026, a detainee with a pending homicide case attempted to forcibly drag Mr. Madriaga into a confined bodega area within the jail. According to Mr. Madriaga, and I quote, "Ayon sa mga naririnig ko sa loob ng kulungan, ang bodegang ito ay sinasabing pinagawa ni dating Congressman Arnie Teves. Isa sa mga impormasyon na nakuha ko ay si Kong Arnie Teves ang gusto magpatumba sa akin," end quotation. Kinumpirma naman po ni DILG Secretary John Vic Remulla na binisita ni Vice Presidente si dating Congressman Teves sa kulungan noong October 19, 2025. Base ito sa ulat ng Inquirer na mismo ang Vice President ang nag-attach sa kanyang perjury complaint laban kay Ginoong Madriaga. Ito ay matatagpuan mismo sa Annex V sa complaint affidavit na minarkahang Annex 5 sa Consolidated Verified Answer ad cautelam ni Vice President Sara Duterte. Just to be clear, this is not intended to accuse anyone. I'm merely raising a concern in our quest to find the truth. If we allow a witness to be intimidated, hurt, or God forbid, killed, then we fail in our constitutional mandate. In terms of what kind of adequate protection I believe would be necessary, I believe that would entail 3 things, Madam Chair. Number 1, that the security for the witness be beefed up, particularly by the National Bureau of Investigation. Second, that his attendance when he is required to appear here be done in a secure manner, that there is sufficient security for his transport here, and also while he is here to testify, that he be put in a secure place. Thank you, Madam Chair.
Would you like to raise the necessary motion with respect to the protective custody of witness Ramil Madriaga?
Yes, Madam Chair. In line with Section 8 of the Rules of the House on Impeachment, I move that adequate protection be provided to Mr. Ramil Madriaga, consisting of three things. Number one, that the security where he is presently detained be beefed up, particularly by the National Bureau of Investigation. Number two, that his attendance, when required by the committee, be secured as well, so that his safety will be, so that his life will not be put in danger. And number three, that while he is testifying before this committee, that again, proper safeguards be put in place to ensure his that his life will not be endangered. I so move, Madam Chair.
So for clarification, the Honorable Jokno, you are requesting, in line with protective custody, is to augment the current security with the NBI security.
Yes, Madam Chair.
You are also requested for sufficient security during his transport to the hearing of the Justice Committee.
And while
you
he
also
is
requested
testifying.
for a secured and safe place for his confinement
While he is testifying. Yes.
while he is testifying before the Justice Committee. So we've heard the details of the protective custody which are being requested by the Honorable Jokno by way of his motion. There is a motion to formalize the same. There's a motion for protective custody of witness Ramil Madriaga, consisting of augmented security by the NBI, security during transport to hearings of the Justice Committee, and secured place of confinement during the hearing as well of this committee. Do I hear a second?
I second the
Madam Chair.
motion.
The same has been seconded.
Madam Chair.
Point of
May we know the pleasure of the Honorable Rodriguez? Are
Madam
you-
Chair, I would like to know whether, directly, whether the motion would transfer custody of Mr. Badriaga to the House of Representatives premises.
May we be clarified on that, the Honorable Jokno?
I did not include that in my motion, Madam Chair.
I understand that the motion is only to make sure that he is in a secured place of confinement.
Yes. Madam Chair, it has already been stated that the Honorable Director of NBI has already assigned personnel to watch 24 hours. Mr. Madriaga in Camp Bagondiwa. In fact, the jail superintendent has already stated that Madriaga has been transferred to a solitary cell so that there'll be no other people there that will endanger his life. And so, Madam Chair, with a presumption, Madam Chair, of regularity of functions and that our witnesses will be fully protected, there's no need for this motion. Secondly, Madam Chair, Ramil Madriaga is a polluted source. He is facing kidnapping with murder charges. In 2021, one member of the anti-kidnapping gang was killed. The PNP member of the anti-kidnapping gang. And then they were arrested in 2022, 2023. That's why he is in jail. And now we're going to give credence to a polluted
Chair.
affidavit.
Point
Madam
of
Chair,
order.
no,
There is
Madam
a
Chair.
point of order,
Let us clarify,
Honorable
we're trying to
Rodriguez.
protect somebody who is a polluted source. In fact, in
Madam
the
Chair.
cases of the
Honorable
Supreme Court,
Rodriguez, there's a point of order.
thank you, Madam Chair.
Let's hear the point of
Premature.
order. The Honorable De
Madam
Lima is
Chair, I
recognized.
submit that it's clearly premature for anyone to raise an issue of credibility on the part of the intended witness. He's not yet testifying. He will testify, and therefore, issues of credibility can be raised in the questioning, in the clarificatory questioning. Mr. Madriaga can be asked about those things during the hearing, the proper stage of the hearing, but not at this point. So it's out of order. Any such statement relating to the issue of credibility, statements like a polluted source, that is not yet proper at this stage of the proceedings.
Would you
Madam
like to
Chair.
raise a motion concerning the manifestations of the Honorable Rodriguez with respect to the credibility of Ramil Madriaga?
I move that particular part of the manifestation of the Honorable Congressman Rufus Rodriguez with respect to Mr. Madriaga being allegedly a polluted source and the related statements with respect to the issue of his credibility be stricken off the records.
Is there any second?
Second, Madam
The
Chair.
same has
Madam
been
Chair,
seconded. Is there any objection?
I will, yes, of course, Madam Chair, because we are
Two,
trying
two
to...
motions are pending now.
Yes.
One is the motion for the issuance of subpoena motion for protective custody of Ramil Madriaga, raised by the Honorable Chel Jokno, and second is the motion to strike off from the record the manifestation concerning the credibility of Ramil Madriaga. The same has been seconded as well.
This representation is not out of order. We are discussing about giving a bundle of rights, 3. All of this to be able to give that advantage, that perceived, safety issues which are not. That's why me stating that to give this bundle of rights, to give this protection, to all of this custody and so forth in a safe place, should not be given to a polluted source. That is the point that I have. And therefore, it is not out of order. We are discussing, we are objecting to this particular motion. And that is the reason why, these are the reasons why I say that we have to know this person whom we are giving all of these extra advantages and extra attention and care which he does not deserve.
Madam Chair,
The Honorable De Lima.
Mr. Madriaga is listed as one of the witnesses for the complainants. And that's why I asked for the issuance of subpoena juris tecum. And it's very clear under Section 8 of the Rules of Procedure in Impeachment Proceedings, protection to complainants or witnesses. The House may, upon proper petition, provide adequate protection to a complainant or witness if it is shown that the personal safety of the complainant or witness is in jeopardy because of participating in the impeachment proceedings. And we have heard the manifestation and the explanation of the Honorable Chel Jokno about the alleged threat to his safety. And therefore, it is very much in order that we tackle the issue of grant of protection in the mode that was described and asked or sought for by Congressman Chel Jokno, and the motion has been duly seconded. Thank you.
We've heard amply the argument of both the Honorable Rodriguez and the Honorable De Lima. For the guidance of the Justice members, our parliamentary status is there's a pending motion by Congressman Chel Jokno for protective custody of witness Ramil Madriaga. The same has been seconded. The same is objected to by the Honorable Rodriguez. There's likewise a pending motion by the Honorable Laila De Lima to strike out from the record the manifestation of the Honorable Rodriguez pertaining to the credibility of witness Ramil Madriaga. The same has been seconded as well, and the same was objected to as well by the Honorable Rodriguez. We shall now proceed to divide the House, starting with the first motion. That is the motion of the Honorable Chel Jokno. Again, for the guidance of the members, the motion is for the protective custody of Ramil Madriaga. Those who are in favor of the motion, please raise your right hand.
May I just clarify?
Yes, please.
That my motion requests, I am moving specifically for 3 things. Number
Yes.
1, that we make sure that there is additional security provided to Mr. Madriaga
You said from the NBI.
in his present place of detention by the NBI. Second, that both in the transport when he is required to come here to testify and while he is testifying, again, that adequate security be provided to him.
All right. So those who are in favor of the motion for protective custody of witness Ramil Madriaga, please raise your right hand. You may put down your hands. Those who are not in favor, please raise your right hand. Honorable Tino. Thank you, Honorable Rodriguez. Those who abstain, please raise your right hand. That concludes the voting. We shall announce the result. With 35 votes in the affirmative and 1 vote in the negative, with 0 abstention, the motion is granted. The Secretariat is requested to closely coordinate with the Office of the Sergeant at Arms and/or Legislative Security Bureau for the protection of Ramil Madriaga. As courtesy by the committee, please also notify the BJMP as well as the respective regional trial court which ordered his detention. So ruled. Indeed, all the pending matters were already addressed by the committee. The chair believes that we should...
Madam Chair.
The chair stands corrected. There's another pending motion from the Honorable De Lima. May we request the Honorable De Lima to restate the motion?
Yes, Madam Chair. I move that the portion of the statement or manifestation of the Honorable Rufus Rodriguez attacking the credibility of the intended witness, Ramil Madriaga, the issue of his credibility, those allegations about being a polluted source, Ramil Madriaga being a polluted source, be stricken off from the records.
There is a motion to strike out from the record the manifestation of the Honorable Rodriguez with respect to the credibility of witness Ramil Madriaga. Do I hear a second? The same has been seconded. Is there any objection? There is an objection. Let's proceed to divide the House. Those who are in favor of the motion, please raise your right hand. You may put down your hands. Those who are not in favor, please raise your right hand. Thank you, Honorable Rodriguez. Those who abstain, please raise your right hand. That concludes our voting. We shall announce the result. With 34 in the affirmative, 1 in the negative, and 0 abstention. The motion is granted. The committee secretariat is directed to strike out from the record all the manifestations of the Honorable Rodriguez pertaining to the credibility of witness Ramil Madriaga. So ruled.
Madam Chair.
We have concluded all the pending matters before the committee, and we shall now proceed to the determination of
Madam Chair.
the Honorable Ridon.
I wanted to return again to the matter of SALN and unexplained wealth. I understand that Congressman Chua had already moved for the subpoena of the SALNs of the Vice President, and I will also be moving for the following documents and for the committee to issue subpoena duces tecum and ad testificandum on the following. A representative from the Bureau of Internal Revenue to bring the following: tax compliance and reported income of Vice President Sara Duterte, her spouse, Attorney Manasseh Carpio, and various business entities in which they hold interest. original or certified true copies of the annual income tax returns, and other relevant documents pertinent thereto, such as VAT payments of Vice President Sara Duterte, her spouse Manasseh Carpio, for the years 2007 to 2025, and the following entities for the periods specified: Metro City Chow Foods Corp., formerly City Hall King Chow Foods Corp., for the years 2007 onwards; GenCorp Industries Inc., formerly Times Square B Foods Corp. And Great Jolly Times Food, for the years 2021 onwards; Carpio Lawyers, formerly Carpio Duterte, for the years 2007 onwards; 888 Bistro, for the years 2021 onwards; Kale 88 Foods Corp., for the years 2021 onwards; Madaya Fisheries Corp., for the years 2021 onwards; Mati City Ice Plant and Cold Storage Inc., for the years 2023 onwards; Amianan Shores Inc., for the years 2023 onwards; Geometry Security and Investigation Agency Inc., for the years 2023 onwards; and Cable Tow 88 Shipping and Marine Services Inc., for the years 2024 onwards. So moved, Madam Chair.
There is a motion for the issuance of subpoena ad testificandum to the BIR representative and for subpoena duces tecum to the aforementioned documents by the Honorable Ridon. Do I hear a second? Any second to the motion of the Honorable Ridon?
Second.
The same has been seconded by the Honorable De Lima. Is there any objection? The Honorable Rodriguez is registering his objection. If you have no other manifestation, we shall proceed to vote. Those who are in favor of the motion, please raise your right hand. You may put down your hands. Those who are not in favor of the motion, kindly raise your right hand. Thank you, Honorable Rodriguez. Those who Thank you. Thank you, Honorable Keith. Those who abstain, please raise your right hand. That concludes our voting. We shall announce the result of voting on this motion. With 34 votes in the affirmative, 2 in the negative, and 0 abstention. The motion is granted. The chair directs the committee secretariat to issue the necessary subpoena ad testificandum to the BIR representative and subpoena duces tecum with respect to the ITR of VP Sara Duterte, her spouse Manasseh Carpio, for the year 2007 to 2025, including the entities for the same period as mentioned by the Honorable Ridon. So ruled. Honorable Ridon.
Madam Chair, I have one more motion relating again to SALN and unexplained wealth. I move that a subpoena duces tecum and ad testificandum be issued to the following: a representative from the Securities and Exchange Commission, and to bring certified true copies of the general information sheet and audited financial statements of the following entities: Metro City Chow Foods Corp., formerly City Hall King Chow Foods Corp., for the years 2007 onwards; GenCorp Industries Inc., formerly Times Square B Foods Corp. and Great Jolly Times Food for the years 2021 onwards, Carpio Lawyers, formerly Carpio Duterte, for the years 2007 onwards, 888 Bistro for the years 2021 onwards, Kale 88 Foods Corp. for the years 2021 onwards, Madayo Fisheries Corp. for the years 2021 onwards, Mati City Ice Plant and Cold Storage Inc. for the years 2023 onwards, Amianan Shores Inc. for the years 2023 onwards, Geometry Security and Investigation Agency Inc. for the years 2023 onwards, and Cable to 88 Shipping and Marine Services Inc. for the years 2024 onwards. So moved, Madam Chair.
There is a motion for issuance of subpoena ad testificandum to the representative of Securities and Exchange Commission, as well as of subpoena duces tecum with respect to the general information sheet and annual financial statements of the business establishments mentioned already by the Honorable Ridon. Do I hear a second? The same has been seconded. Is there any objection?
Madam Chair, objection. And
You're recognized, Honorable
grounds for
Rodriguez.
objection. May I know first why these companies registered with the SEC will be subpoenas in its record? Is there a nexus between this to the allegations in the complaint, third and fourth complaint? May we know the relevance of these corporations to the present impeachment case against the Vice President?
The proponent first, Honorable Ridon, followed by the Honorable Keith Flores.
Mahalaga po yung pagpapaliwanag mula sa una, sa mga kinita po ng mag-asawang Duterte Carpio from their own personal income, which will be reflected from the annual income tax returns. Pangalawa, mula din po doon sa mga corporate documents kung saan po sila kasali. Sapagkat doon po natin makikita kung yung pong mga other lawful income para maipakita na ang lahat po ng kanyang kinita over the course of 17 years from 2007 ay mga lehitimo pong kita mula sa sahod at mula po sa kinita mula sa propesyon at mula po sa mga negosyo. So, meron pong clear relevancy. Ito pong mga SEC documents po na ito dahil dito natin makikita kung kumita ba o hindi ito pong mga kumpanya na ito sapagkat kung kumita po ito, maipapaliwanag ng atin pong pangalawang Pangulo at ng kanya pong mister na talaga pong kumita ng tama over the course of 17 years from other lawful income katulad ng propesyon at iba pang mga negosyo ang kanila pong pagsasama. So dito po maipapakita ng atin pong pangalawang Pangulo na hindi po unexplained wealth. Ito po kanyang pagkakaroon ng 88 million na net worth in 2024 kumpara po sa kanya pong kinita na cumulatively sahod from 2007 to 2024 na more or less mga 30 million to 40 million pesos lamang po, Madam Chair.
The Honorable Flores.
Thank you, Madam Chair. Madam Chair, I'm joining the objection of Congressman Rufus Rodriguez only on the following grounds, Madam Chair, that the request being made by Congressman Ridon covers periods when the respondent was not yet the Vice President, Madam Chair. I'm going back to the decision of the Supreme Court when it said that we can only file impeachment complaints against an impeachable officer for things done during the incumbency or while she is holding the impeachable office. So by requesting documents or data or figures that would include the time when she was just Vice President or Vice Mayor, I think, in 2007, or holding other positions that are not yet or may be considered impeachable, that's where my objection is, Madam Chair.
Honorable Ridon, would you like to comment to that?
Tama naman po yun. Pero what we would want to be able to see is a complete financial picture of the Vice President from the time that she commenced the public office in 2007 as a Vice Mayor up until today. That would be a proper objection with due respect if we had ended our request previous to 2022. But to be clear, I think a big chunk of all of these businesses' requests will most definitely cover up until today, Madam Chair. And more particularly, there are specific firms here which basically cover the term of the Vice President already. Geometry Security, Amianan Shores, Cable Tow are some examples. But to be clear, all of these are firms that had been listed in the 2024 SALN, which is why I think the nexus between the documents of the SALN and the corporate records is established as we speak, Madam Chair.
Would you
Madam
like to
Chair.
make additional manifestation?
May I secure from Congressman Ridon a statement of ultimate facts in the third and fourth complaint, which mentions these corporations? Are there any? None.
There is none.
None. Second, are there annexes that would show in the third and fourth complaint that would, mention and that will pertain to why you are going to ask for subpoena ducis tecum to the SSC and for the records there? Are there annexes in the complaint?
There is none.
Madam Chair, clearly this will be the biggest fishing fleet expedition that we are doing. Because it was, we only deal with ultimate facts. In fact, we are trying here to determine whether there is violation of the 6 grounds of the Constitution as stated in the 2 complaints. And so therefore, how can we have that, Madam Chair? So that's the first one. Secondly, did I hear from you that you want records from a law office? I heard something because this is new to us. This is a surprise to us, all of us here, that they are now a subpoena for entities that are not included in the complaint. So are you saying there's something about a law office?
To be clear, these are in the SALN of the Vice President for 2023 and 2024. So I think there is nothing that prevents this committee from basically issuing subpoenas on documents that are actually public documents, Madam Chair.
No, I'm asking specifically. There was a statement. You're asking for subpoena for a law office.
Yes, because our assumption is that this is an incorporated law office because it was stated as one of the business interests of the Vice President in her SALN.
Aware of the privilege communication between lawyers and client? This will exactly violate that provision of privilege. You cannot subpoena law firms for representing a person either accused or in impeachment cases. How can we subpoena a law firm for acting as a lawyer for the Vice President? Can you give us a reason why we should subpoena law firms under the rules of court and under the Code of Professional Responsibility? We cannot subpoena records of a law firm.
Sure, court records or communications between clients and the lawyers are absolutely privileged communications. But if this particular law firm is an incorporated entity within the Securities and Exchange Commission and had been submitting annual audited financial statements year after year and general information sheets, I don't think we are precluded as a committee, as an impeachment proceeding, from requesting these particular documents. We are not talking about conversations between the clients of Duterte Carpio or Carpio lawyers. We are talking about their financial output year on year. And to be clear, this is precisely the justification of supporters of the Vice President as to why her net worth, had ballooned to 88 million as against a computed cumulative salary of 30 to 40 million pesos. So I don't think there is reason to, in fact, object to getting all of these financial documents, whether from a corporation or whether from a law firm that is supposedly registered in the Securities and Exchange Commission.
Madam Chair,
May I call the Honorable Jokno first?
perhaps it would be more prudent if we could have the motion of Representative Ridon in writing so that we can consider all the angles and the aspects to that request. I think that we would need to tread carefully when it comes to these matters, especially given the points raised by Representative Rodriguez.
Motion, hearing suspended. Hearing is resumed. The committee heard already the arguments of both the proponent and those who are opposing the motion. This is with respect to the motion of the Honorable Ridon for the issuance of subpoena ad testificandum to SEC representative and ad duces tecum, subpoena duces tecum with respect to the GIS and audited financial statement of certain business establishments mentioned already by the Honorable Ridon. Since we have heard already the arguments of both the proponent and those who are against, we shall now proceed to vote. We are reminded that we are a collegial body. All decisions come from the majority. So the justice members are reminded to be ready to vote. Again, the motion is to issue subpoena ad testificandum to SEC representative and subpoena duces tecum with respect to the certified true copies of GIS and AFS of the business establishments mentioned already by the Honorable Redon. Do I hear a second? The same has been seconded. Is there any objection? There is an objection. Those who are in favor of the motion, please raise your right hand. You may put down your hands. Those who are not in favor of the motion, please raise your right hand. Thank you. Those who abstain, please raise your right hand. That concludes our voting. We shall announce the result. With 14 votes in the affirmative, 2 in the negative, and 3 abstention, the motion is hereby declared granted. The committee secretariat is directed to issue the necessary subpoena ad testificandum to the representative of SEC and subpoena duces tecum for the production of GIS and AFS of the business establishments mentioned in the motion of the Honorable Redon. So ruled. May we know if there is a representative of the respondent, Vice President Sara Zimmerman Duterte, to inform the committee about the necessity of issuing the compulsory processes with respect to the witnesses she wishes to present and the documents she wishes to present as well to the committee. The chair wishes to state for the record that despite the non-attendance or non-appearance of the Vice President and her counsel in today's hearing, they are welcome to participate at any stage of our proceeding. That is in pursuit of due process which we accord to the respondent in this impeachment proceeding. Having said so, are there any other matters?
Madam Chair.
Madam Chair.
Madam Chair.
The Honorable D.S. Konghun first before the Honorable Marcoleta.
Thank you.
Madam Chair, for the purpose of our next hearing on April 14, 2026, the committee should consider adopting the sequence of the grounds for the third impeachment complaint and receive the evidence for both impeachment complaints jointly, considering that they may have in common evidence. I propose that for our hearing on April 14, the committee should determine the probable cause for the following grounds for impeachment. Number 1, the Sabala complaint, the Vice President committed culpable violation of the Constitution and betrayal of public trust, malversation, graft, corruption, and other high crimes. The Cabrera complaint, the Vice President committed betrayal of public trust, graft, and corruption. Number 2, for the Sabala complaint, the Vice President committed culpable violation of the Constitution and betrayed the public trust by committing malversation, grafts, corruption, and other high crimes. The Cabrera complaint, VP Duterte committed graft and corruption, bribery, procurement irregularities, and command responsibility. Number 3, that VP Duterte committed capable violations of the Constitution and betrayed the public trust by corrupting and bribing officials of the Department of Education. And for the Cabrera complaint, that the Vice President committed bribery, procurement irregularities, related to corruption in the Department of Education. Madam Chair.
May we confirm if that is your motion already, the Honorable D.S. Conghon?
Yes, Madam Chair.
So there is a
move.
motion to adopt the sequence of topics already read by the Honorable D.S. Conghon for the purpose of our determination of probable cause.
Madam Chair,
The Honorable De Lima.
it was not quite clear to me which specific grounds indeed are to be first tackled for the April 14 hearing. The movant or the proponent actually made mention about culpable violation of the Constitution, betrayal of public trust. But which of these specific grounds? The first ground, I'm talking about the Cabrera, the Saballa et al. Complaint. The first ground is about the anomalous disbursement of confidential funds for the OVP. The second is anomalous disbursements of confidential funds for the DepEd. And the third ground is bribery and other graft and corruption. And those three grounds are actually covered by the 5 motions for subpoena that I put forward and already approved. So those witnesses, those resource persons, subject of the subpoena, will be tackling these first 3. Anomalous disbursement of confidential funds, OVP, anomalous disbursements of confidential funds, DepEd, and the bribery and other graft. So it was not clear to me the manifestation earlier of the proponent. Is he also referring to these grounds?
Yes.
The Honorable De Lima is asking if the proposed sequence of topics pertains to 1 confidential fund of DepEd, 2 confidential fund of OVP, and 3 bribery in DepEd.
First OVP, then DepEd, then bribery.
Yes, Madam Chair.
The Honorable D.S. Conghon confirmed to that, Honorable De Lima.
Thank you for the confirmation, because that is also the intended sequence insofar as the complainants are concerned in the Saballa et al. Complaint. Thank you, Madam Chair.
So can
Madam
we rule
Chair?
on the motion? The
Madam-
Honorable
Yes,
Rodriguez.
Madam Chair, I'd like to be clarified. In the third complaint, there are 6 grounds where we have found, the committee has found form, substance, and grounds sufficient. Also, the 5 grounds in the fourth complaint, how do we hear this? 6 grounds, third complaint, and 5 grounds of the fourth complaint. Are we going to go one by one for the third and then the fourth? We're going to mix because ground number 1 is ground number 1 also of the fourth complaint. Ground number 4 of the fourth complaint is ground number 2 in the complaint. So are we going to mix them if they have the same subject matter, or we will go, because I'm not clarified on this, or we will go by grounds per complaint? Madam Chair, how do we go about this?
The way the chair understands with the proponent of the sequence of topics is that the allegations that pertains to the confidential fund of OVP, then DepEd, then bribery with in the DepEd are taken together, allegation by allegation, the third impeachment complaint and the fourth impeachment complaint, so that we can receive jointly the evidence which will be submitted by the parties in relation to these 3 topics: confidential fund of OVP, confidential fund of DepEd, and then bribery in the DepEd.
Yes, joint.
After that, Madam Chair, what will be the next to be heard, so that we will know how we will go along with this hearing? So I understand 3, that's fine, because confidential funds is number 1 in the third complaint and number 1 in the second complaint, or the fourth complaint. The second one, OVP, that is precisely ground number 2 and 3 of the third complaint, which are also part of the fourth complaint. And then, of course, the third one is the bribery. That is also the third and fourth complaint, and also the fourth and fifth complaint of the fourth. So how about the others? How are we going to go for the others? Or we go there once we finish the first 3?
May we hear from the endorser
Yeah.
how they want it to be presented for
Thank
the
you,
purpose
Madam
of
Chair.
determination of probable cause?
For the moment, for today, we are only manifesting what we intend to present or tackle or discuss, or for the April 14 hearing. Those three grounds, those first three grounds under the third Sabalia et al. Complaint. And from there, we should be able to determine now and manifest for the record what should be the next ground to be tackled, if still necessary to tackle any of those other grounds. Thank you.
There is a pending motion to adopt the sequence of topics proposed by the Honorable D.S. Konghun. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the motion is granted. The sequence of topics as proposed by the Honorable D.S. Konghun is hereby adopted.
Madam,
The Honorable Marcoleta.
thank you, Madam Chair. Madam Chair, if you may I make a manifestation as regards to my observation on how the rules
You may proceed.
on how the rules were applied between the Marcos and the Duterte complaints. There appears to be
Madam Chair,
inconsistency
The
in
Honorable
the application
Dilima.
point of
rules.
order. We of course respect
There's
the
a
right.
point of order, Honorable Marcoleta. We have to hear it first. The Honorable Dilima.
We of course respect the right of even a non-member to make any manifestation, some manifestations that are relevant to the issues at hand. Now, those matters have been tackled already, exhaustively discussed in the course of the proceedings for the determination in substance, sufficiency in substance, as well as the determination of sufficient grounds. That issue has been resurrected a few times already. And even the Honorable Chair has actually refuted that point, that there is no different treatment. And if there's any different treatment, it's because it's mandated or it's called for, necessitated by the specific facts of these cases. So there's no point to further touch on this matter.
Madam
so I
Chair.
move that we do not allow
Madam
the
Chair.
Honorable Marcoleta to
With all
press
due
further.
respect to the Honorable Marcoleta, the point of order is sustained.
Madam Chair, may I appeal?
Please make sure that your manifestation is germane
Yes,
to
ma'am,
our
because-
current impeachment proceeding.
Because
Please be reminded
Yes, ma'am.
not to move back. We have
Yes,
to
ma'am.
move forward.
Every now and then, the issue of due process comes up, and we will always go back on the fair application of the rules between the Marcos and the Sara Duterte complaints. I'm just making an observation, Madam Chair, and I think I should not be precluded from
With all due
making my
respect,
observation.
Honorable Marcoleta, a point of order has been raised and the same has been sustained. So I hope we will conclude on our manifestation pertaining to the alleged double standard. Please shift to other manifestation which are germane to our current discussion in this impeachment proceeding.
Okay, ma'am. May I proceed to what Congressman Rufus made earlier regarding the nexus to impeachable ground?
That nexus pertaining to the motion for issuance of subpoena to the representative of SEC has been ruled upon as well, Honorable Marcoleta, with all due respect.
Okay, so I am precluded from making any manifestations as a member of the House?
It is
Madam Chair?
precisely because the manifestations which are being raised are issues which have been ruled upon by the committee already.
Yes, ma'am, but due process prevails at any stage of the impeachment process. So, wala naman po sigurong masama sa
But please
manifestation.
confine your manifestations to the current subject matter of our impeachment proceeding. Please do not go back. The majority of the Justice Committee ruled already on the issue that you are raising. Let us respect the decision of the majority.
Yes, ma'am. Just a comparo between the two complaints sana, if I may be allowed.
That is going back again to the issue of double standard. With all due respect, Honorable Marcoleta.
I defer to the authority of the chair. Thank you.
Thank you. Thank you. Just for the record, if the lawyers or the respondent is present in today's hearing, they are welcome to read to the committee the witnesses they intend to present for the purpose of the determination of probable cause. That is for the record. Now, if there are no other matters which the members of the Justice Committee wish to raise,
Madam Chair,
the Honorable De Lima.
one other matter. I think this committee needs to anticipate any eventuality that between now and the next scheduled hearing, which I understand is on April 14,
That's correct.
if certain incidents, motions, or requests are also filed between now and the next hearing, wouldn't be proper for us, and I think it would be well within the prerogative of this committee, especially so that under House Resolution number 892 that authorized the committee to continue the conduct of impeachment proceedings, one matter or one action, power, or function that this committee can do or can exercise is conduct hearings and other proceedings related to impeachment complaints within its jurisdictions. So what if, Madam Chair, there would be further motions, requests, or incidents submitted or filed by any member of this committee? Wouldn't it be proper for us that this committee be allowed to hold meetings outside the scheduled hearing dates to discuss and act on subsequent motions, manifestations, requests, and such other incidents and matters that will be submitted for the committee's consideration? As with the hearings that we're conducting now, this should also be, of course, with notice to the parties and their counsels, and should be open to the public. I so move, Madam Chair, so that we don't have to wait, especially if these are urgent requests, we don't have to wait for the next hearing before this committee can act on those incidents, if any, only if there would be such subsequent incidents. Thank you.
There is a motion from the Honorable Laila De Lima to allow the committee to conduct meetings outside of this hearing. That is for the purpose of addressing urgent motions, manifestations, or any other matters relevant to the current impeachment proceeding. Do I hear a second?
Second, Madam Chair.
The same has been seconded?
My objection, because, we have 14, 21, and 29. Very clear that whatever is filed could be tackled on April 14. So it's not necessary that we will have additional hearings. We set this, it's in my calendar now. I still have the diary, which is not used by younger lawyers. But I think we have set already 14, 20, 29. So let us just, that is, also a premature speculation that there may be motions. And all motions will be tackled when it is filed on April 14. Thank you, Madam Chair.
With that, then we shall proceed to vote. There is a motion.
Madam Chair.
The
just a
Honorable Tino.
Clarificatory question.
This is your clarificatory question.
So distinction between meeting and hearing. So the meetings will, if I understand correctly, will still be open to the public, and they will still require quorum so that any motions and so on will be considered valid actions of the committee. Is that correct?
Let's hear from the
Chair?
proponent.
Yes, Madam Chair, because that is only on the premise that there would be subsequent motions or incidents between now and the next scheduled hearing in anticipation, anticipatory, or in case, or only in the eventuality that such incidents are submitted or filed. And it's a given that there would be a quorum, a quorum would be required, and that it would be open to the public. It's a given. But this is meeting we can consider it a special meeting outside of the scheduled evidentiary hearings, which would start in April 14. That is my motion, Madam Chair, my point. Thank
Madam
you.
Chair.
Does that satisfy the Honorable Tino?
Madam Chair.
The Honorable Adjong.
Thank you, Madam Chair. Madam Chair, does the committee already have that mandate or authority to exercise calling for an emergency meeting should there be a need to do that without necessarily the committee adopting a resolution? That's number one. Number two, Madam Chair, is I do agree with Manong Rufus that there are already indicated dates for the committee to conduct the next committee hearings. And if we are to, again, anticipate, for example, that there will be an additional hearings for the committee to conduct, that would also indicate the need for this committee for a 3-day notice ruling, Madam Chair. So we don't actually know exactly when would be the additional between the interval, in the interval in between dates that have already been identified by the committee. So again, Madam Chair, if there's already that authority by the committee chairperson to exercise calling for an emergency meeting, then with all due respect to Congresswoman De Lima, there is no need for the committee to adopt such resolution.
I think this is only for the purpose of addressing urgent motions, pleadings, or manifestations that the motion of the Honorable De Lima is being raised. But nevertheless, that meeting to address the urgency will still be subject to the requirement of notice, hearing, as well as quorum, and the 3-day notice rule. No? So I think it will not harm our proceeding and even the pre-scheduled hearings on the 14th, the 22nd, and the 29th. No? So can we proceed to resolve the motion?
Again, my position, Madam Chair, with all due respect to Congresswoman De Lima, even if we don't adopt that resolution, the committee can already exercise that. It's already it's an inherent power of the committee to call for a special meeting.
Madam Chair, my point is, let's just be very clear about it. Because yes, under the House Resolution number 892, I mentioned earlier, may I just quote again, resolved further, that during the recess of the House of Representatives from 21 March 2026 to 3 May 2026, the House Committee on Justice is hereby authorized to continue the conduct of impeachment proceedings and exercise powers necessary and incidental thereto in the same manner and with the same force and effect as if the House of Representatives were in session, including the following. 1, conducting hearings and other proceedings related to impeachment complaints within its jurisdiction. 2, setting, scheduling, and adjusting the calendar of hearings and other related proceedings. And there are 2 other matters like receiving, acting upon, and resolving pleadings, acting upon petitions, requests, motions. But my concern here only is that since we have predetermined dates of hearing already, which are for the evidentiary hearings, there might be, just anticipatory, so a standby authority, standby discretion, especially the chair, to hold or to call for a meeting outside of the regular scheduled hearings already in the calendar. Because one other aspect, as I cited earlier in the House Resolution number 892, setting, scheduling, and adjusting the calendar of hearings and other related proceedings during the period of recess. So this is just a standby authority. And to be very clear about holding other proceedings, meetings outside of the regular dates of hearing already predetermined. That is my point for clarity, for orderly and efficient conduct of the proceedings. Thank you.
The argument actually of the Honorable Rodriguez and the Honorable Adjong is that that power of holding a meeting is already inherent in the committee. But I don't see nothing wrong about ruling on this motion so as for us to re-emphasize the authority of this committee to hold hearings to address matters with extreme urgency. So with that, would the Honorable Rodriguez and the Honorable Adjong reconsider their position with regards to the motion of the Honorable De Lima?
Yes, Madam Chair.
Madam Chair,
We are okay with the motion.
yeah,
You are withdrawing your objection. How about the Honorable Adjong?
yeah, I'm not objecting actually. I'm just trying to avoid redundancy here. So
You
if
have
it's
no
already
objection.
inherent power, so there's no need for a resolution. But there's no objection, and I do understand the position of Congresswoman De Lima. Thank
With
you.
that, let me just reiterate, there's a motion from the Honorable De Lima to authorize the committee to hold meetings outside of these hearings. That is to address urgency. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the motion is granted. If there are no other matters, I think it's past 2 o'clock in the afternoon.
Madam
We've done
Chair?
a lot of things for today's hearing. The Honorable Percy Sendanya.
It has been a very productive day for us and for the Filipino people. I move to adjourn, Madam Chair.
There's a motion to adjourn or motion to suspend?
Let me withdraw my motion and reiterate, motion to suspend, Madam Chair.
There is a motion to suspend our hearing today. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, our hearing today is hereby suspended.